Test. Okay. All right. We are streaming online, but we are not on the record yet. This is the appeal of DC Solar Solutions Incorporated, OTA case number 2402154565. Welcome to the Office of Tax Appeals, or OTA for short. My name is Andrew Wong, and I'm the lead member of the OTA panel that will be conducting the oral hearing for this case. On today's panel, in addition to myself, we have Administrative Law Judges Shireen Ridenour and Greg Turner. Also present is our hearing reporter, Ms. Lynn Alonzo. Before we go on the record, I would like to cover a few general matters. This hearing is being live streamed to the public and recorded, and the video recording will be made available on OTA's YouTube channel. As a result, please be mindful of any personal, confidential, or sensitive information that you might share or display, such as home addresses, social security numbers, and the like. Also, Ms. Alonzo will report this hearing verbatim and prepare an official hearing transcript, which will be made available on OTA's website. To help Ms. Alonzo make a clear record, I have 4 requests of the parties. Number 1, please speak slowly, clearly, and directly into your microphone. Number 2, please do not speak over each other or interrupt when someone else is speaking. Number 3, please answer verbally using words. And number 4, please mute your microphones when not speaking. If Ms. Alonzo cannot hear, understand, or identify someone who is speaking, she has permission to interrupt the oral hearing at any time to get clarification. This oral hearing is taking place before OTA, which is a separate state agency from the California Department of Tax and Fee Administration, or CDTFA. OTA is not a court, but an independent appeals body staffed by tax experts and is independent of the state's tax agencies. As I noted earlier, I'm the lead panel member for purposes of conducting this oral hearing. However, my 2 co-panelists and I are co-equal decision makers and may ask questions of either party during the hearing. Our 3-person panel will decide all the issues presented to us, and each of us will have an equal vote in making those decisions. Ms. Alonzo, are you ready? All right, let's go on the record. This is the appeal of DC Solar Solutions Incorporated before the Office of Tax Appeals, OTA case number 2402154565. It is Wednesday, April 22nd, 2026. The time is 9:02 a.m. We are holding this hearing in Sacramento, California. I'm Andrew Wong, the lead member of the 3-member panel hearing this case, and with me are Administrative Law Judges Shireen Ridenour and Greg Turner. The individuals representing the appellant, DC Solar Solutions, could you please introduce yourselves?
Hi, Jesse McClellan on behalf of Trustee Christina Lovato.
Ms. McClellan, can you please repeat that and closer to the mic? Our hearing reporter did not get that.
How's this? It's better? Okay. Jesse McClellan on behalf of Trustee Christina Lovato.
Christina Lovato, Chapter 7 trustee for the estate of Double Jump.
And Jeff Hartman, General Counsel for Ms. Lovato.
Thank you. And will the individuals representing the respondent tax agency, the California Department of Tax and Fee Administration, or CDTFA, please introduce yourselves?
Good morning. I'm Kevin Smith from the CDTFA Legal Division.
Jared Noble, also with the Legal Division.
Jason Parker, Chief of Headquarters Operations Bureau.
Good morning. All right, we are considering 3 issues today. Issue number 1 is whether mobile solar generators, or MSGs, qualify as mobile transportation equipment. Issue number 2 is whether disallowed claim non-taxable sales should be further reduced. And number 3 is whether appellant was negligent. Appellant, is that a correct statement or summary of the facts? Or sorry, issues?
Yes, it is. Yes, it is.
Thank you. CDTFA?
Yes, it is.
Thank you. The mute button, yeah, you might have to hold it and not just tap. So, all right, let's talk about exhibits. Appellant had originally identified and submitted proposed exhibits 1 through 30, and then supplemented those with 2 other exhibits, exhibits 31 and 32. CDTFA, did you have any objections to the additional exhibits?
We don't have any objections to the introduction of the new exhibits, even though they were late. We just want to note that this was not a new argument. It was asserted in the October 2023 decision, page 11, lines 5 through 20. However, we welcome any evidence that is brought in, so there's no issue.
Okay, thank you. So appellant's exhibits 1 through 32 will be admitted into the record as evidence. And then CDTFA has identified and submitted proposed exhibits A through K. And then CDTFA, no other exhibits, is that correct?
That's correct.
And appellants, no objection or any objections to the exhibits?
No objections.
Okay, CDTFA's exhibits A through K will be admitted into the record as evidence. Mr. McClellan, you have one witness, Ms. Lovato, is that correct?
Yes, sir.
Okay, and then CDTFA has no witnesses, right?
That's correct.
Okay, I will swear in the witness right before I turn it over to you for your presentation. As far as the time goes, it's anticipated that the oral hearing would take approximately 240 minutes. As follows, appellant, you've asked for 180 minutes total. CDTFA has asked for 40 minutes, and then I've budgeted 20 minutes for introductions and panel questions. Any changes to those estimates, Mr. McClellan?
I can't be certain, but with any luck, I think we'll get out of here faster than what we initially anticipated.
Okay. CDTFA, 40 minutes?
That's correct.
Okay, great. All right, any final questions from either party? Mr. McClellan?
No.
CDTFA?
No.
Okay, I will therefore swear in the witness. Ms. Lovato, could you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
All right, thank you. All right, Mr. McClellan, the floor is yours. You have 180 minutes.
Thank you. I appreciate that. As was mentioned in the introduction, this case involves sales of mobile solar generators, or what's referred to as an MSG. It's equipment designed to produce energy. The documents that you see may also refer to it as a mobile solar unit or a mobile solar facility. All of those refer to the same thing. Now, you address the primary issue in a way that we agree with. We see it as being accurate, but naturally there's some sub-issues that we're going to get into today. The primary and what we view as a threshold issue in this case is whether MSGs are for use in transporting persons or property, thereby qualifying as mobile transportation equipment under Code Section 6023 and Regulation 1661. If an MSG is not MTE, then the parties agree that the sales at issue are exempt sales for resale. And if it's resolved that the MSGs are MTE, appellant concedes that the sales are subject to tax. Another sub-issue that goes along with that is that if it otherwise qualifies as MTE, if it's designed to be hauled by a passenger vehicle, there's an exclusion that applies. Another sub-issue that we would like to address that was discussed at the pre-hearing conference and in briefing is what is the meaning of component parts under Section 6023 and Regulation 1661. We think that's an important issue, and we hope today to better convey the reasoning for why we think it requires a definition, and that potentially up to this point in Adler, while the application of the term to the tanks and the boxes in that case are consistent with the definition that we think should apply. It didn't define what component parts is. But we're going to get into that into some detail. Ultimately, if these issues are resolved in favor of appellants, then the subsequent issues are moot. And those are issues that involve the liability as computed by the audit. In summary, those sub-issues are whether or not tax applies to MSGs that never entered California, and whether or not payments made for MSGs that were manufactured, I'm sorry, let me say that another way. Payments made for MSGs that were not manufactured should be transferred to MSGs that were manufactured. If that doesn't make sense now, it will, hopefully by the end of this. And then, of course, we've got the negligence penalty. So, again, our primary argument is that MSGs are not for use in transporting persons or property, and as such, they do not qualify as MTE. I think there's really a full stop there. But I understand that there's been some different thoughts and approaches as far as addressing this issue. In terms of Adler, what Adler doesn't do is look at a situation like this, where you start with what amounts to be a trailer or a trailer frame or a trailer chassis, and you modify it to such a degree that it no longer legally qualifies as a trailer. It can't be used to transport property, which is part of the definition under Vehicle Code Section 630 as it pertains to a trailer. So what Adler doesn't do is address this question, which is what happens when you have something that might qualify as MTE, and we're not stipulating that it does out of the gate as far as the trailer part, but what happens when you take that part and you modify it to such a degree that it's no longer useful for the purpose for which it was initially designed, and it becomes something else? I mean, another way to think about this within the confines of MTE is an aircraft jet, where the engines are removed and it's leased out for purposes of display at shows. But it can't fly any longer and it can't transport people. I mean, does it remain MTE? We don't think that it would, because then it wouldn't be for use in transporting persons or property. And there's a number of other examples that you could apply to that. In any event, what I'd like to do is to just give you a quick rundown of the entities that were involved here. The transactions were somewhat complex, and hopefully I can demystify that for the panel. And then I'm going to take Ms. Lovato's testimony, the trustee, just to firm up some facts. We're going to try to stay out of what she has already testified to in her declaration that is submitted as Exhibit 24. And then I'm going to walk the panel through some photos, and we'll talk about the specific mobile solar generator here, look at the parts list to get an idea of everything that goes into it, describe to you why we think it can't be used to transport persons or property, how it was physically incapable. We'll talk about the transactions themselves, which also will demonstrate to the panel that these transactions were designed around federal tax credits that were really a very meaningful part to these transactions, in that per the tax opinion that we recently submitted as Exhibit 31, and the lease that was controlling and in place under Exhibit 11, that there was explicit directive to use it strictly for production of power. And in fact, it actually says that it specifically will not be used to transport persons or cargo. And then ultimately, from there, we'll address some of the sub-issues we've just covered in a little more detail. And then we're going to address the audit issues that we just summarized. And I don't believe that we'll need the full time to do that, but if at any time during the discussion, if there's a question that comes up that's nagging at you, don't hesitate to interject, and I'd be happy to answer it as best I can.
Sorry, just one note. I think we're going to aim to take a break around 10:30 a.m., just to give you a heads up about that, so you can plan your presentation accordingly.
Okay, that'd be great. I would hope to be finished before then, so we'll see how this goes. And with that said, again, turning back to the entities, just to provide some context, I think we may potentially come back to this for various issues as it relates to the audits. But DC Solar Solutions manufactured and sold mobile solar generators. Okay, they were the manufacturer, they marketed them, and I'll refer to DC Solar Solutions as Solutions. Now, DC Solar Solutions, for the transactions at issue, sold to tax equity investment funds. Those funds were owned primarily by larger Fortune 500 companies that potentially would have use for these sorts of products, like insurance companies, for disaster sites, things of that nature. And then there was DC Solar Distribution, which was closely held, and ultimately they were tasked with maintaining, marketing, and leasing the trailers on behalf of the funds. For all intents and purposes, the funds never really received or accepted the MSGs. Many of them, as we'll get into, and I don't know if you guys looked into the background of this case, but it's been written about in the media and national media fairly extensively. But ultimately, the department may get into this. I mean, there was a fairly significant fraud scenario that was perpetrated by the owners of DC Solar Solutions and DC Distribution. Now, ultimately, we're not here to defend their actions. We don't think that their actions that were found to be wrongful have an impact on this case at all. And you know, the reason why we're here today is to try to make certain that the right result is reached in this tax appeal, such that these investors that were defrauded will have an opportunity to recover as much money as they were defrauded of back. So while there is that aspect to this case, we anticipate the department to get into it. We don't believe that it's relevant. We don't think that it has any impact on the legal questions here or the factual issues. Now, to the extent that it is relevant, we'll address that. I mean, the reality is that not all the MSGs that were purported to be built were built. So that impacts the liability. But the department, the audit staff has stipulated to that. I don't think we have a problem there. And if we do, we're prepared to address that. With that said, what I'd like to do is to call Christina Lovato, the trustee. Christina, can you go ahead and state your name and title for the record?
Yes, Christina Lovato, Chapter 7 trustee.
And would you provide a brief summary of your professional background for the panel?
Sure. Excuse me. After working for about 7 years as an environmental consultant, I returned to school and attended UCLA for law school and received my JD in 2003. After that, I went on to work at an LA-based law firm doing real estate and environmental law for some time. Excuse me, getting over a cold.
Take your time.
Thank you. After relocating to Reno, Nevada, I was then appointed to the Chapter 7 bankruptcy trustee panel in 2011. And since that time, I've been administering Chapter 7 cases and on occasion Chapter 11 cases since 2011.
Thank you. And when were you appointed as the trustee for the DC Solar Solutions and related cases?
That was on March 22nd, 2019.
And does the outcome of this appeal impact your compensation in this case in any way?
No, it does not impact my compensation at all.
Okay, and just for context, approximately how much time have you spent working on this case?
Since 2019, I would approximately thousands of hours, but I have not kept detailed records.
Okay. And you previously prepared a declaration that was signed on May 5th, 2025, is that correct?
That's correct, yes.
Okay, and does that declaration and all that's contained in it still remain true today?
Yes, it does.
Okay, thank you. And can you just provide for the panel a brief overview of your understanding of the relevant activities of DC Solar Solutions and DC Solar Distribution?
Sure. DC Solar Solutions was the entity that marketed, manufactured, and sold the mobile solar generators, which we refer to as the MSGs. They mainly sold them to large institutional investors which form tax equity funds to purchase the MSGs to take advantage of renewable energy tax credits offered by the federal government. DC Solar Solutions was the related entity that was responsible for leasing the MSGs to third parties. So they basically managed, stored, and maintained them, or were to be maintaining them, and leased them to third-party entities on behalf of the funds. So basically, the funds would enter a master lease with DC Solar Distribution to lease them to third-party users.
Okay, thank you. And just to clarify, so DC Solar Solutions would market, manufacture, sell to the funds, and DC Solar Distribution would maintain and lease the funds, correct?
That's my understanding, correct?
Okay, thank you. And was a tax opinion prepared by Nixon Peabody for DC Solar Solutions that provides guidelines regarding qualifications for the federal tax credits?
Yes, that is correct.
And you've reviewed that tax opinion?
I have reviewed it, yes.
Okay, and can you confirm that that's the same tax opinion that was provided in Appellant Exhibit 31?
That's correct. It
Thank
is.
you. And was it, the same opinion was used for each fund transaction at issue, is that correct?
Yes, it was the same opinion. However, various details were changed, just minor details like the fund number. There were approximately, I believe, around 35 funds. The number of MSGs that each fund would buy changed, and then, of course, the name of the fund would be different.
Okay, thank you. And as it pertains to the representatives of the funds and them accepting receipt of the MSGs at the time of sale, was that actually done?
No, I'm not aware that any fund actually took possession or receipt of the MSGs. They typically were built, and then DC Solar Distribution maintained and stored them.
Okay, thank you. And did DC Solar Distribution lease all the MSG units that were produced?
There were some leases, but overall, most were not leased to third parties.
Thank you. And are those details included in the declaration of Melissa Davis also?
Yes, that is included in her declaration.
Thank you. And to your knowledge, did distribution report sales or use tax on its leased units?
Yes, I believe they did.
Okay. And for units that were not leased, what is your understanding of where they were stored?
Typically, they were stored at manufacturer facilities or nearby manufacturer facilities. So, also at the DC Solar Solutions headquarters in Benicia and some nearby warehouses also. And then some fraction of them were located at lessee properties. Notably, the motor speedways across the country had a lease of some of the MSGs, so they were at different facilities nationwide.
Excellent, thank you. And can you tell us who the third-party manufacturers were during the audit period?
There were three manufacturers, so one in California, in Woodlake, California, known as US Tower. Extreme Manufacturing in Las Vegas manufactured some, and then Forest River manufactured some in Indiana.
Excellent. And since we're not going to restate all that was included in your declaration, I'll just state for the record that you previously testified in your declaration that part of your work as the trustee included locating, recovering, and liquidating the MSGs to help recover money for the estate. Is that correct?
That is correct.
Okay. And during that process, were you able to confirm that approximately 2,500 units were located at or around Extreme Manufacturing in Nevada?
Yes, that's correct. That was the number that were found in the Las Vegas Valley, essentially in Clark County.
Okay, thank you. And when those items were located, am I correct that there would be a recording of the VIN number, the model number, the fund owner, and some other information along with that?
Yes, that's correct.
Okay. And as far as the units located in Nevada manufactured by Extreme, did that make up the majority of what was located from those locations?
I believe so, yes. There were many located at Extreme Manufacturing as well as warehousing nearby.
Okay. And all of that can be determined by looking to what's referred to as the SMS database, where all of this information was recorded as they were found?
Yes, that's correct.
Okay. And do you have any reason to believe that SMS database is inaccurate?
No, I do not. That was prepared by a third-party auctioneer that was compiling the data of what we could find nationwide of MSGs.
Okay, thank you. And is there any reason for you to believe that the units produced by Extreme that were located in Nevada during the recovery process were ever sent to California for any reason?
I have no belief that they were sent to California. They were found in basically brand-new, unused condition in storage.
Okay, thank you. And wasn't it true that there were thousands of units at the time that this was taking place that were also located inside California?
Yes, there were definitely many located in California, correct.
Thank you. And to your knowledge, were any of the MSGs at issue in this appeal ever for use in transporting persons or property?
No, that is not their intended purpose, and I'm not aware of any use of them for that purpose.
Thank you, Ms. Lovato. No further questions.
CDTFA, did you want to cross-examine the witness?
No, thank you.
Okay. I'll turn to my co-panelists to see if they have any questions for Ms. Lovato, starting with Judge Turner.
I don't have any
I don't have any questions. Thank you.
Judge Ridenhour?
Not at this time, thank you.
I also do not have any questions for the witness at this time. You may continue with your presentation.
Thank you. So I think what I'd like to do is next turn to Exhibit 32 if we can. And Exhibit 32 is a compilation of the photos that were otherwise contained in Exhibits 1 through 30 that were previously submitted. My hope is that it would make it more simplistic just to have them in one spot. But what I'd like you to do, if you could, is to start with the last page of Exhibit 32, which I think you guys have the large single file, so if you just go all the way to the end, page 2048, we can start there, okay. So what you're seeing there are photos of Carson Trailers. And of course, Carson Trailer is the primary vendor that Solutions use to purchase the trailer base. And if you look at the Exhibit 10 trailer purchase reports, what you'll see is that each and every trailer is defined as a flatbed, okay? So it's some variation of a flatbed. So if you look at this last page, which contains, let's see here, 8 different photos. I believe that the items purchased would be what's identified as a car hauler. And if you, as we go through and we look at the various versions of the MSGs, you'll find that that's consistent. So that was the base of what was purchased. If you scroll up to the next page, again, there's some flatbed trailers there, which will give you an idea of what was initially purchased. And then we start getting into photos that include a fully constructed MSG. And I think what I'd like to do, if I can, is direct your attention bear with me, I just want to get to the right page here.
Sorry, Mr. McClung. I just wanted to clarify, on the last page with the pictures of all the different trailers, which trailer were you highlighting as being the ones utilized in the MSGs? Was it the flatbed, or I thought you had said car hauler?
Bear with me, let me get back to that. I don't believe it's what's identified as flatbed. I believe it would be what's identified as car hauler. And I think that will become more apparent. In particular, if you look at the center trailer under car hauler that has tracks and an open center portion, from looking at the photos of the MSGs that we'll see in a bit, it appears that that's exactly what was used for at least some of the MSGs. Now, it appears that more simplistic models used something more akin to the top car hauler, where there was wood and there was not the metal internal frame. So I believe from the photos that I've viewed and the photos that are in the record, that it's those two trailers that form the base of what ultimately became a mobile solar generator.
So it was the car hauler, and what was the other trailer?
Well, the two photos, there's 3 in the car hauler photo that you're seeing. There's 3 photos. I think it would consist of the middle one, right, where you can see the tracks and sort of the open center. And then I believe it would consist of the top one also. Because there are photos where you'll see that there is essentially a wood base.
I see, okay, got it.
Okay, and if we can go to what I believe would be Bates 1682. I'm sorry, that's completely wrong. If we can go to what is Bates 2029, which is the same exhibit 31, just the first page, and then scroll down to Bates 2030. Okay, so in looking at that, that's the result of at least one model. And as we scroll through the photos, what you'll see is that there were some modifications, some refinements, but we believe that for all intents and purposes, the products were the same. Some did not have the lights. Some did not have a generator. Some used a different type of box to house the electrical components. But you know, one of the things that we'd like to draw the panel's attention to is the framing, okay? So again, keep in mind that we started with what was identified as a flatbed trailer. A flatbed trailer generally is designed to carry equipment or vehicles that can be rolled up onto the trailer. Now, as constructed, an MSG had railing around the entire frame, including the rear portion of the frame, which we'll see in other photos, making it impossible for it to function for the purpose for which it was designed. And ultimately, when you look at the parts list that we've provided as Exhibit 29, there's dozens of different parts that go into this, and it provides a value for them. And the total value is approximately $50,000, according to that exhibit. And the value of the trailer is approximately $3,000. So, I mean, we're not talking about buying a trailer here and, I don't know, adding some framing to the side to allow it to accept cargo better, you know, to allow it to hold more items, or perhaps even a shell that's commonly used when it comes to landscaping and carrying around lawnmowers and edgers and things of that nature. Nothing of the sort. I mean, what started as a trailer, and whether or not that trailer qualifies as MTE independently is a question we'll probably get to. But we think what's most important is what was sold. And ultimately, Solutions didn't sell trailers. There's no reference of trailer in the purchase agreement at all. What they sold was a mobile solar generator. And as constituted at the time of sale, there was simply no space on that trailer that was feasibly available to transport any property. Now, the department has argued, and if you scroll down, let's just, if we can, scroll down to 2031. That's the inside. You can see the tracks that I referenced previously from the photo from Carson Trailer. And then 2032, if we can take a quick pause here, there's what's referred to as a, excuse me, a job box. Now, the department has suggested that that job box was capable of transporting property. respectfully, we think it might be misunderstood. But that box, which has a close-up photo, is filled with electrical components. And I'm not an electrician, but I've been around long enough to have some understanding of what you would want to do with electrical components, and one of those is not to store things in the box where they're at. You know, you put a screwdriver in there and it ends up hitting a positive and negative, and that's not going to be a good thing. So certainly it wasn't designed to transport things. It wasn't for use for transporting any things. But that was one theory about, okay, well, how do we get to the point where this was for use in transporting? That was one theory that was proffered. We don't think it's supported. Scrolling down through these, you can see at Bates 2035, again, some photos of the various parts and components. This version has modified a little bit. You'll see that the front enclosure looks a little bit different than what we just looked at. Again, for all intents and purposes, the same thing. I just would like to point out Bates 2036. At the bottom, there's a close-up of the locking pins that are built into this structure. And I think this goes to the modifications and the custom modifications that were made to make this in product specifically usable for solar panels and a mobile solar generator. 2037 also is a front view. And then Bates 2038 is something I'd like you to take a look at if you would. Again, this demonstrates the purpose of me suggesting that the trailer with the tracks was the one that's being used. I think this makes it pretty clear that that's a match there. But you can see the modifications that have taken place here, and that the framing for the batteries there are bolted, and some of it appears to be welded, which would prevent it from being used for transporting property, right? You're not sliding things in and out of there. You certainly can't get a vehicle into there, notwithstanding the fact that you have bars surrounding it that would literally preclude it from being used for that purpose. So what have, and then the next page are some options, some components of the MSG that could be added, a charging station and lights. And finally at 2040, you've got a photo of an MSG in operation where the lights are extended and being used. So ultimately, putting that all together and borrowing a phrase that is used for leases in general is that this was not in the same form as acquired. I mean, there were substantial and significant modifications. The threshold to determine whether or not there were substantial modifications for leasing property under 1660 is a 20% change in value. Well, again, we're talking, to put this into context, the value of the parts as shown in the parts list that we've submitted as Exhibit 29 total is approximately $50,000. The trailer portion is $3,000. So really, the trailer is a part of the MSG. The MSG parts are not an addition to the trailer. And we think under the definitions that do exist for component parts, that certainly solar panels, generators, parts that go into an MSG don't qualify as a component part of a trailer. And we'll get into that in some more detail. I briefly previously alluded to to the form of the transactions and why that matters. And I summarized it, and I'll get into a little bit more detail here. But ultimately, when you look at the tax opinion, what becomes apparent is that a major driving force behind these transactions was that there was going to be a 30% credit that was going to be obtained in the year that it was purchased and first put into use. Hence, you've got a 30% down payment of approximately $45,000, and then the balance is to be paid via promissory notes that would be satisfied by the funds through the amounts that are generated by distribution leasing these to third parties. Now, the Melissa Davis Declaration, which is contained in CDTFA exhibits at page 2466 through 2566. You don't have to go there now if you don't wish. I just wanted to have it on the record for you so you can find it. Does a very good job of laying out all the relevant facts. And Melissa Davis was a forensic accountant that was retained by a law firm that was or is working for the trustee in the proceedings in a lot of different various matters. And she goes through in great detail and explains the entities, how the transactions worked, and ultimately who was doing what. What she explains is that distribution was supposed to produce $1.7 billion in lease receipts to satisfy the notes. What it did produce was $12 million. So we're talking significant gap there. Now, some of that was in California, and distribution reported tax on those lease receipts, consistent with this being treated as tangible personal property. And then they also did the same in other states where they were reporting tax on the lease receipts. So ultimately, that's where this house of cards kind of came crumbling down, is that lease receipts weren't generated, so you couldn't satisfy the notes. So the CARPOV started to use new investment funds to circulate through this process and essentially record it as lease revenue, when in fact it wasn't at all. It was really just deposits from new investors. All of this came to light at the end of 2018. Bankruptcy was filed. The principals and owners are incarcerated at this point. Now, the tax equity aspect of this, we believe, is important because in order to qualify for the tax credit, there has to be specified use. The opinion that's written is quite lengthy. It's a little bit hard to digest, and if you're ever having a hard time sleeping, pop it open and you'll be good to go. But it makes it clear that the property has to be placed into service of energy production on a continuous basis. That, again, is Exhibit 31. The master lease that was entered contemporaneously with the purchase contract on all of the transactions at issue expressly states that the mobile solar equipment will only be used for its intended purpose and that it's exclusive for energy production. And ultimately, there's no indication that it was ever used for anything else. And as we've argued, we don't believe that it's physically capable of being used for anything else. Now, again, mobile transportation equipment only includes equipment for use in transporting persons or property for substantial distances. So the legislative history demonstrates that really that equipment was primarily industrial in nature. It was sponsored by the railroad industry as a means to bring a more efficient way to report tax on items that were consistently moving in interstate commerce. So you have what's identified as traditional items, railroad car boxes, semi-truck trailers, aircraft, vessels that clearly qualify as mobile transportation equipment. And MSG does none of that, right? It only produces power. It was designed from a transactional standpoint that a major aspect of it would be federal income tax credit. And it was constructed in such a way that precluded it from being used to transport persons or property. Again, all of this is quoted in the briefs and in the papers, but just briefly I'll go through some of it. The tax opinion, which is Exhibit 31 at page 31, states that the minimum, which enables the facilities to be relocated as needed. I'm sorry, let me just, bear with me here. The cost of the wheels included in the mobile solar facilities constituted less than 1% of the cost of the facilities. And except that amount, which enables the facilities to be relocated as needed, no portion of the mobile solar facility serves any function other than the generation and temporary storage of electricity. In particular, quote, no part of the structure can be used for any other purpose, such as transporting persons or cargo. The tax certificate that is part of the tax opinion also says no portion of the mobile solar facilities serve any function other than the generation of temporary storage of electricity. All of that, in essence, is incorporated into the lease at Exhibit 11, including paragraph 2, sub 2, which says that the solar equipment will be placed in service for purposes of Section 48 and 168 of the Internal Revenue Code of 1986. Shall only be used for its intended purpose and within normal capacity. Exhibit 11, paragraph 7. Now, to gain further clarification on this, we went to the DMV and asked them what they thought about this equipment. We asked for an opinion as to whether or not it qualified as special mobile equipment. And of course, special mobile equipment is defined in relevant part as equipment that is not for use in transporting persons or property. So if it's MTE, it's not special mobile equipment, and vice versa. DMV came back and confirmed that this is indeed special mobile equipment. It fits the definition to a T. It's not propelled by itself. It's only incidentally moved. And it cannot and is not designed for transporting persons or property. And again, we've covered that the physical makeup of this simply would not allow it to be used as transportation of persons or property. And then finally, it simply was never used for that purpose. As you heard Ms. Lovato testify, CDTFA has not alleged that it was ever used to transport persons or property. And ultimately, the law as written says for use. That's what it says. So if it's not for use in transporting persons or property, we simply cannot see a finding that it's MTE in accordance with the law. Now, CDTFA has essentially set forth two arguments for why they think it actually transports property. I've already addressed one. One is the job box. The other theory is that it transports itself. That was addressed in Adler, and Adler made the statement that it has to be designed for transporting something other than itself. Either a person, in the case of a truck and a crane, which was addressed in Adler, or property. And this does neither. Ultimately, as constituted at the time of sale, MSGs were not for use in transporting persons or property. We don't think that fact is reasonably disputed, and therefore it cannot qualify as MTE. Now, there's some additional sub-issues to that. I can pause there if the panel would like for questions, or I can carry through. I think you mentioned there was a break at 10:30.
You can continue, and we'll hold the questions till your presentation is done.
Great, thank you. So there's a sub-issue, of course, and that's, well, whether this falls within the exception for being hauled by a passenger vehicle. Now, ultimately, we don't believe you get to that question in this case, because we think that the first question that has to be asked is the one that we just addressed, is, well, hey, look, is this for use in transporting persons or property? And if that resolves in the affirmative, then you ask the question, well, does it fall within the exception? And if you don't answer the first question in the affirmative, then it doesn't have to be accepted because it's not in there in the first place. Nonetheless, I respect that there's some different viewpoints on how this is supposed to be analyzed. And we addressed the responses in the pre-hearing conference response as it related to this issue. And I think it speaks for itself, and if there's questions on that I can answer, I'd be happy to try to do that. But ultimately, one of the things that is interesting on this question is, is it the trailer that you're looking at being capable of towed by a passenger vehicle, the bare trailer? Or is it the, the full MSG, which in our view is no longer a trailer by definition because it can't transport persons or property. And by legal definition, it's just not a trailer. So it's like, okay, well, the only way this can make sense in our view is that, well, you'd have to look at the unloaded weight of the trailer to determine if it qualifies or not for this exclusion. But then, it's like, well, wait a second, but we didn't sell a trailer. Solutions didn't sell a trailer. So if you conclude that it's, qualifies as MTE, that's fine. But if it doesn't, if it's not sold in that state, if it's stripped of the purpose for which it was designed, and it's no longer a trailer, then I think the appropriate viewpoint that's consistent with the facts before us is, does an MSG period constitute MTE? I think it's clear that it doesn't. Again, we made this submission regarding the passenger vehicles. We're able to identify numerous SUVs that were capable of transporting the fully loaded MSG. And then, of course, if we're looking at just the trailer, there's a number of vehicles, passenger vehicles, that are capable of towing that around. And before we get into component parts, I'd like to briefly address Adler because it kind of dovetails into the component parts question. Now, of course, this panel is familiar with Adler, and so is the department, and it addressed 3 separate items: a large tank, a small tank, and a box. The tanks were designed to hold hazardous waste, so it was, it was a product that held property. But the catch there is that it couldn't be transported over the highways. So while it was capable of holding property, it wasn't for transporting that property. It was also precluded from doing so under the lease. The case makes note that the large tank was identified as special mobile equipment. Those factors, I think, are on all squares with the MSG here, okay? Now, ultimately, Adler found that the tanks, the large and the small tank, were not MTE. And we believe that conclusion is correct because it wasn't for transporting persons or property. Interestingly, my view is that it certainly is capable of transporting property, perhaps not hazardous waste, but certainly a tank that's designed to hold fluids could transport property. So it's not so much that it couldn't transport property, it's just that it wasn't for use in transporting property. And I would suggest and submit that an MSG is even further removed from MTE because it can't even hold property. I mean, it has no ability to hold materials in the same way that a tank can. It's designed strictly to produce energy, and by viewing it, it's clear that it's not designed to hold or transport cargo. In any event, as the panel is aware, there was two prongs that were established in Adler. One being, was the equipment for use in transporting persons or property substantial distance, including specifically listed equipment, first prong. We think that resolves in favor of appellant here, and MSG clearly is not designed or used for use in transporting persons or property. The second prong gets a little trickier, and ultimately, the way that it's approached in a sense is, well, let's take a look at the exact same product, right? Let's take a look at the MSG, but we're just going to look at it under sort of a different analysis, if I understand the way this is applied. And we'll look at whether or not the trailer all by itself is MTE. And then if that qualifies for MTE, then we're going to say that, well, all these component parts that are attached to it, by extension, become MTE, okay? And that's some language that I want to look closely at. I don't think that approach is correct, respectfully. I think that what you have to look at, and by the way, I think that worked fine in Adler. The facts in Adler, I think, worked fine. The facts in this case, I think, are different, and to the extent that it's agreed generally that a mobile solar generator is not MTE, we don't think that if you look at it in such a way with the way it was constructed, that then allows it to be treated as MTE. In other words, if they didn't buy a trailer, let's just say that they built the frames from scratch and constructed it in a different fashion, such that you couldn't look at anything independently, because there truly was no thing that was independent, but you ended up with the exact same product. Arguably, under that test, you would get two different results for the exact same product. So that makes me concerned that potentially the test needs to be modified. And here's the thing, and this is where it gets me, is, I've been talking about the component parts since we filed our first brief. What are component parts? And I've spent a lot of time looking into the term, and ultimately, what I found, interestingly, is that the term is defined in Regulation 1593 and 1594 that address aircraft and vessels respectively, right? I mean, both of those things are expressly identified as MTE, and part of that regulation addresses component parts. Well, in relevant part, those definitions say that in order to qualify as a component part, it has to be integral and necessary to the product to which it is attached. I also looked to the vehicle code, and there's a vehicle code section that's cited in the brief. I can't think of it off the top of my head at the moment, but in summary, it defines what constitutes component parts of a vehicle. And not surprisingly, under the integral and necessary framework, it says that things like tires and engines and side panels and things that you would expect to be needed in a vehicle for its operation. And you see some of that in the annotations too. So if you look at the annotations, some of which CDTFA cited, a cargo hold in a ship is a component part because it's designed to hold cargo and to retain it safely in transportation. There's an annotation on lights that are attached to a vessel. Well, it allows it to navigate safely. It allows it to perform the purpose for which it was designed. in a safe fashion. That is fundamentally what a component part is. Now, when you look at the plain language of 6023, and I think it's cited verbatim in 1661A1. It says MTE includes tangible personal property which is or becomes a component part of such equipment. Well, here's the thing, is if I understand the department's position correctly, they're saying that all tangible personal property that's attached becomes a component part. And of course, they're going to have an opportunity to clarify that. Judge Wong, we talked about it at the pre-hearing conference, and my understanding is what was resolved is that if it's permanently affixed, then it's a component part. So in other words, any permanently affixed tangible personal property becomes a component part. But we don't think that's consistent with the language, because if you look at the language, ultimately, it implies that not all tangible personal property is a component part. It says TPP, which is or becomes a component part. And ultimately, if you say that all tangible personal property becomes a component part, then it really leads to absurd results. I mean, we're talking animals or tangible personal property, food, trees, collectible coins, all sorts of different things. And if that's attached to what's otherwise considered MTE, is it naturally considered a component part? We don't think it is. We think what makes sense of this scheme is what was in place at the time that it was drafted, which, by the way, was in place at the time it was drafted. So at the time that the legislature drafted 6023, 1593, 1594, and the associated statutes that supported those regulations existed. And of course, when it comes to interpretation, there's a statutory canon of construction that says that the legislature is aware of the law at the time that it drafted the statute. So in other words, at the time they drafted the statute, they knew what 1593 and 1594 called a component part, and used it in this statute, which establishes a presumption that they meant the same thing. And when you apply that definition, it actually makes perfect sense, by the way. It makes perfect sense. Because then, if you have a component part of a trailer, for example, that can be, again, it can be any of the fundamental parts that exist when you buy it, or if you have to replace those. Or if you were to put a shell on it, that enable the property that you're transporting to be better protected, or potentially be able to load more. Or you can add walls, sidewalls to it that would allow, you can add a ramp or a different type of ramp. Those would be parts that would be integral and necessary for the purpose for which the trailer is designed, okay? And if you just use tangible personal property as the threshold, I think, number one, you're violating the plain language of the law, because the law makes it clear that not all tangible personal property is a component part. And if it was, naturally the legislature would have simply said that all tangible personal property attached to the equipment becomes a part of the equipment, period. It wouldn't need to say tangible personal property that is, which that in and of itself implies that there's some that's not, or becomes, which again implies that something has to happen before it's treated as a component part. So we would ask this panel to examine that issue, which I think it has to be, in order to administer and provide clarity in this area of law. We think that the term is a term of art. It has a history of definition within the Revenue and Taxation Code before this was drafted. And I think if it's applied in the way that we are asking for it to be applied and defined, it makes perfect sense. It leads to sound results. It leads to scenarios where if what's attached helps the product to which it's attached perform its intended purpose, then it qualifies. And it avoids absurd results, which potentially one could say that it's absurd to say that a manufactured unitary product that's sold for the sole purpose of generating power is somehow for use in transporting persons or property. Unless we can factually establish today that a mobile solar generator is capable and for transporting property, the department has stipulated that it's not for transporting people. That's pretty obvious. So really, unless we can factually establish that it was capable and for use in transporting property, respectfully, we don't see how there can be a conclusion in accordance with the law that says it's MTE. We think it's threshold. Now, from here I've got audit liability issues. These, depending on the questions that come back, or at least my presentation will be shorter than what I've just done. I can keep carrying through to 10:30 if you'd like. It's 10:11 by my watch. What would you like me to do, Judge?
Let me check with my panel. Let's go off the record very quickly.
Okay.
All right, let's go back on the record. Just to note that I think we'll take a break now, and then we'll resume in about 10 minutes so we don't interrupt you in the middle of an argument. So, all right, let's take a break. Let's go off the record. Come back at 10:22.
Thank you.
Thank you. All right, Ms. Alonso, are we ready to go back on the record? Okay. Parties ready? Okay, let's go back on the record. Mr. McClellan, you can continue with your presentation.
Yes, sir. Thank you. Again, the next thing I'd like to get into are what I'm calling liability issues or audit issues. They really are, a mix of legal issues within there also. Before I get to that, one of the things in the statements that have been made up to this point that I forgot to mention is that we do feel like this case is on all fours with Standard Oil v. Philbrick. Of course, the panel is likely familiar with the case. The case also involved a trailer that was modified to such a degree that it could no longer be used as a trailer. The question in that case was whether or not it qualified as special mobile equipment under Vehicle Code Section 575, which again defines in relevant part equipment that is not for use in transporting persons or property. That is precisely the question. I think those words carry the same meaning in that code section as the meaning in this code section. They're plain and ordinary words. They're not terms of art, and because the Court of Appeals specifically addressed that question, and it addressed a question that involved a product that started with a trailer, and that trailer was so substantially modified that it rendered it unusable for transporting property other than the drawworks itself, that it really meets all of the factors that are relevant in this case. With that said, turning to the liability and audit issues. That will need to be addressed if the primary MTE issue is not resolved in favor of appellant. Bear with me, just trying to find my spot here. Okay, so 2 issues. Number one, whether MSGs that never entered California are subject to California sales tax. And of course, the allegation here is that all of the sales are subject to sales tax. The next issue that we'll address is whether payments made for an MSG that was not produced can be transferred to an MSG that was. We see both of these as being fairly straightforward and well supported factually and by the law. And in any event, the facts show that Extreme Manufacturing, located in Nevada, manufactured 2,389 MSGs. That's shown in Exhibit 25. The SMS database, which is something we discussed previously, is a database that was maintained and created by the trustee as a control to report to the bankruptcy court regarding what units were found, where they were found, who owned them, what fund they belonged to, what their VIN number was. Now, using the Extreme Manufacturing report, which also includes the VIN number, in the SMS database, we were able to determine, okay, these units that were located in Nevada were also manufactured by Extreme. And through testimony, we're able to establish that these were unused. And ultimately, those then could be cross-referenced to the audit by fund to determine whether or not some of these units remain in the audit. And for the record, some of these units were removed in the re-audit process. And there was a re-audit that was recently performed, and I sort of thought it was just an oversight and that it would be resolved. And so we had requested the department make the adjustment. They elected not to make it. But ultimately, we think that through Exhibit 5, through Exhibit 25 and Exhibit 9, specifically leading up to Exhibit 5, we were able to succinctly identify the units that were produced by Extreme Manufacturing and located in Nevada in an unused condition. And that given those facts and the fact that there were also thousands of units available in California, mind you, they weren't really leasing these things. That's the problem. That was really, sort of the straw that broke the camel's back. They didn't have enough people to lease these things. They were supposed to generate $1.7 billion in lease receipts. They generated $12 million. Very, very significant gap. So they had a lot of these things sitting around. And frankly, that's probably what led to the nefarious activity where they just stopped manufacturing new ones. They were relabeling these things. I mean, they were supposed to produce 14 to 16,000. They produced 7,000 and just represented to investors that they were produced through faulty documents. So ultimately, there was a large surplus of these units that just never got used before everything came crumbling down. So given those facts, again, that the unit was manufactured in Nevada, it was located near the manufacturer in a storage facility or at the manufacturer, that there was significant numbers of these units in California, and the trustee has testified that they were found in an unused condition, that it's more likely than not that the units never entered California. Okay. So in that case, what does the law say? Now, Revenue and Taxation Code sections 6010.5, 6051, 6201, which pertain to sales, gross receipts, purchases, and use, all state that it pertains to being in this state, okay? So that's sort of the fundamental nuts and bolts in the Revenue and Taxation Code for this purpose. This issue was also addressed in Montgomery Ward, the State Board of Equalization, a 1969 California Appellate Court case. Formal site is 272 Calap 2nd, 728. That case involved sales of merchandise from Montgomery Ward to California residents that were made on a credit card. So Montgomery Ward, in theory, knew, hey, look, these are California customers. And California said that under those circumstances, well, you're going to have to collect use tax because you have a presence inside California. And there's a presumption that they're coming back to California to use these things. The court ultimately found that didn't actually pass constitutional muster. I represented a case called Guarantee RV Inc. in 2010, where it was a similar scenario before the Board of Equalization, and they were selling RVs in Oregon, and customers would go up there, buy them, complete the transaction, and there was question as to, well, is there a presumption of taxability in that case? Ultimately, that was resolved in favor of the taxpayer and that it wasn't. So, as it pertains to 6247, well, let me back up for a moment here. Evco v. Jones, 1972, 709 U.S. 91, also established that, quote, a tax levied on the gross receipts from the sales of tangible personal property in another state is an impermissible burden on commerce. So the U.S. court has spoken on this as well. There's annotations that in summary say the same. One is about coins that never enter California. And the quote that I have from annotation 220.0094 is, neither the sales tax nor the use tax applies with respect to sales of coins that never enter California. Makes sense. Now 6247 exists, okay? Now 6247, if you're not readily familiar with it, is a presumption that is triggered where property is sold to a California resident and shipped outside the state. The code section actually used delivered outside this state. Now 6247 is a rebuttable presumption, but we don't believe the presumption applies at all here, because 6247 applies to scenarios where products are delivered outside of the state to the customer. There's a presumption it's going to come back in and be used. But to the extent it's not delivered outside of the state because it's never touched the state, that presumption technically does not apply. And that was the subject of Montgomery Ward. The other argument that CDTFA has set forth, which is fair and reasonable, is well, wait a second, the contracts call for this stuff be delivered in California to Benicia. And so therefore, we're going to call it taxable. And that's found under Exhibit 6. Here's the thing, is Civil Code 1640 establishes that where either through fraud, mistake, waiver, breach, that a particular term isn't satisfied, then ultimately you look to the intent of the parties and figure out what was actually done. And in this case, I mean, hey, look, this is a really unique case. This is really an extraordinary case. I mean, you've got a situation where the owners are sitting in jail, having either been found or pled guilty for fraud for long periods of time. There's a lot of money that's involved, and really that fraud involved specifically representing that there were a number of units that were being produced that never got produced, okay? So that fact matters, okay? That fact's not in dispute. And that when all of this came crumbling down and the trustee set out to look for these, she found a bunch of these in Nevada, to their surprise to some degree. They weren't expecting to find 2,500 units clustered in Nevada, but they did. They also found over 1,000 units in or around U.S. Tower in California, and approximately 600 units in Benicia. I share the California amounts because ultimately, if there was a need for a MSG in California, they didn't have to go to Nevada to get it. They could just pull from this excess inventory that they already had in California. Again, putting all the facts together demonstrates that it's more likely than not that these never came to California. And as it pertains to the contract term, we know that not all the contract terms were fulfilled. In fact, many of the material ones were not. The number of units stated in the contracts were not fulfilled. They didn't produce them all. They fell short by over 100%. The amounts paid, the promissory notes that were established under the contract, we know that those were not fulfilled. So ultimately, within the totality of the circumstances, the evidence before us, I think we can safely say that even if the contract says, hey, this is to be delivered to California, we know it wasn't. And the reality is that if you read that language, it says that in order for the sale to be complete, in order for title to transfer, this needs to be delivered to California. So another way to look at that is that the terms of the sale were never completed. They were never satisfied, and therefore a sale didn't occur. We think probably the more reasonable and accurate approach is that the sale, in essence, did occur, that the the delivery requirement was waived, that the fund ultimately came to own the particular MSGs at issue, but that they just never entered California. So with that, what we are requesting is that as computed in Exhibit 5 and summarized within the first few pages of that, all of the detail is there to support the summary, down to the transaction, down to the fund, and then we tie it into the audit working papers. It all reconciles. That there's 1,051 units that are contained in the audit that need to be removed. Because they never came to California. Okay, so the next issue is whether payments made for units that were not produced can be transferred to units that were. Here to help frame this, I would call your attention to Exhibit 6, which is the contract for sale, and then the related Exhibit 7, which is the commissioning reports. Now, the commissioning reports demonstrate that each and every MSJ, I keep saying that, each and every MSG that was the subject of a sale contract was identified separately. Part of the process for qualifying for the tax credit is there had to be an engineering report that was done, okay? So each one of these received a separate commissioning report. There were listing of the VIN numbers for each and every unit. The sale price was established based on a price multiplied by the number of units. The down payment that was paid equally was established from an amount multiplied by the number of units identified in the contracts. So it's not as if there was a lump sum contract here where a bulk price was paid for as many MSGs that you can get to us, okay? That was not the case. So with that background, when we got involved with this case, one of the first things that CDTFA did was to send it back to the audit staff to say, hey, look, you know, some of these things really need to be looked at. So we did that, and the payment amount was one thing that we looked at, and it was resolved that, okay, look, these things are being listed at $150,000, but we can see through the financials, through the bank statements, through the general ledgers, that that amount was not paid, and that the design was that it would be satisfied via a note where the money would flow through distribution through leases that never took place. So essentially the money didn't flow through. So the department recognizing that, well, if we set up a liability, it's just gonna give rise to a bad debt offset credit, and that's an unnecessary, inefficient gyration of the law. So let's just look at what was paid, and we'll use that as the basis for the liability. I think a fair and reasonable approach. I think, and still is, by the way, the approach that should be taken, and that's the approach that we're advocating for. What happened is that they initially applied that average sale price to every MSG in the contract, even if it wasn't built. And I think we finally convinced them that, hey, look, that's not gonna fly. Like, you can't assess tax on property that doesn't exist. It's not gonna pass muster with Section 6006 sale. You've gotta have tangible personal property that's transferred. Title can't attach to something that doesn't exist. So ultimately they removed those units that weren't produced, narrowed it down to, okay, fine, we got it down to the units that actually exist in physical form. But rather than make the adjustment the way we thought it would be made, after looking closer at the audits, we realized that really what was done was that the payments were just consolidated to a fewer units, depending on whether, depending on some different factors, like whether or not it was located outside of California, whether or not inside California. And we certainly appreciate the department's work on this. I worked with Ms. Ellis Hugg, the former administrator of Santa Rosa, for months on this. I mean, we put a ton of time into this. And she was great. And she was on her way out. She was going to retire. I don't think she had to do this. But I've known her for a while, and she was very gracious with her time and really spent a lot of time getting into a lot of detail as far as the bank statements and general ledgers and drilling down to establish exactly what each fund had paid. And ultimately, it's all traceable. And came to what we believe is a very accurate number. And the average of that number in summary is $4,900, approximately $4,900. I've got it exactly here somewhere. So $44,946. Okay, I got it. I've got to shut up here pretty quick because I'm losing my ability to speak. But that's where we think this should land. So we've got what we've identified through Exhibit 5 and the related sources. All of the units that are subject to tax, and here's what it captures. It captures units located in California, found in California, even those that came from out of state. It also includes those located out of state that originated in California. We think there's an exemption potential there. We just can't support it factually at this point. But to be as reasonable as we can based on the available evidence and facts, we've included those units located out of state if they originated in California, unless they were expressly excluded because it was a unique transaction like a sale for resale. But what we are asking to be excluded are those units manufactured outside of California and found outside of California where the evidence supports it's more likely than not they never entered California. We think the law supports that conclusion. Some of those units, again, have already been treated that way. Some have not. And then we believe that as far as the measure for each unit, it should be established by unit, not based on the amount that was paid. And ultimately, these were individual transactions in essence. So MSG number 1 was sold on the one hand, MSG number 2 was sold on the other hand. And that if one wasn't produced, then that price that was paid just comes out of the equation, we think appropriately so under the law. And that if you do that, we've done the math, and it's in Exhibit 5. You multiply the number of units subject to tax, which again include units inside California, basically all the units inside California, and the units located outside of the state that originated in California. You multiply it by that average that was established by the audit staff painstakingly. You get to a tax amount of $15,189,397. With that, again, we respectfully submit that the units are not MTE because they're not for transporting persons or property. We think these issues we just addressed become moot by extension. Ultimately, the penalty becomes moot by extension. But if it's not resolved in that fashion, then we think at a minimum that these adjustments to the audit have to be made to make sure that it's accurate under the legal approach that's being taken. And I'll just very briefly address the penalty, and then I'll wrap this up. Now, there was no penalty assessed in the first audit. The auditor comments note that they were provided with all of the records that they needed for the audit, that all of those records were sufficient for audit purposes in both audits. The first audit, I think, appropriately recognized that this appears to just be a legal mistake. I don't see any evidence, despite there being some pretty clear fraudulent activity on the part of the Karpovs. I don't think they started the business that way. I don't think they started with that intent. That doesn't really matter. But from everything I've read and I've saw, I think it eventually led down that path and lacked integrity and eventually got himself into some trouble. But ultimately, as it pertains to sales and use tax, here's the thing, is that if this is not MTE, which as we know isn't an easy question. I mean, it's kind of a tough question to get through. And I say that and I think, well, actually it's not that tough of a question. I mean, if it's not transporting persons or property, it just says an MTE. But I don't know that it's going to go that smooth, and it gets complicated. And we have to recognize that within the context of a penalty, right? So as it pertains to whether or not it was reasonable for them to stand their ground and to say that these were not MTE, we think it was. They were under an appeal. So in the second audit, because they came along and their changes weren't made, ultimately they assessed the penalty in that audit. And in our position is that, well, there was a timely appeal filed, it was still proceeding, and that there's a fairly thin line as to whether or not this is MTE or just TPP. And if it falls on the side of TPP, which we think it should, they report it accurately. So it really is a determination based on a very complicated legal question. And they reported accurately, just to close that, because distribution reported tax on its lease receipts, which I wouldn't advise a person to report differently. I mean, I guess the other option would be to pay tax on costs and there would be no tax on lease receipts. But ultimately, under the circumstances, because tax was not paid on costs, it was appropriately applied and reported on lease receipts. So therefore, we do think that the negligence penalty should be abated in the event that it's not rendered moot by the other issues being resolved in favor. With that said, to the extent I have any more time, I'd like to reserve it on rebuttal, and we have nothing further.
Thank you, Mr. McClellan. All right, I will now turn to my co-panelists to see if they have any questions for the appellant, starting with Judge Turner.
I'd like to wait for a respondent to present their testimony, and then I'll have questions.
Okay. Judge Ridenour, do you have any questions for appellant?
Yes, and this is for Ms. Lobato. Thank you for being here. I'm just wondering, there's a lot of talk about possible adjustments for the MSGs that never made it into California. How do we know specifically that they were manufactured, stored in Nevada at one of the two locations, as opposed to California or entering California for use and then going back to Nevada? Like, I just was hoping for a little bit more information on that.
Sure. Excuse me, Christina Lovato for the record. The DC Solar Solutions actually had a kind of a secondary headquarters in Nevada and Las Vegas. And we're working closely with Extreme Manufacturing and to produce those units that were found in Nevada. So we can directly link to the Extreme Manufacturing reports of production with the VIN numbers to those units that were found essentially unused, stacked in the warehouses owned and controlled, well, not necessarily owned, but controlled by DC Solar Solutions in Nevada. So there were a couple different facilities in Nevada that house these brand new units. They're very, I mean, typically the way to transport them would be to put them on flatbed trailers. I mean, it's an expensive proposition to be moving bulk quantity of MSGs around, even as close as Nevada and California. It would be very costly. So we would have no reason to suspect that they made these in Las Vegas and stored them, but had somehow moved them around for use. Also, there was really no use for them because there was such difficulty finding third-party lessees to take these units. So they were essentially stored, and you could verify that they had never really been outside. And then several were still, or more than several, I mean, actually hundreds, were still stored at the Extreme manufacturing facility where they were produced.
Thank you very much, I appreciate that.
And I may be able to help out in that regard for you also, and I can go into as much or as little detail as you'd like, but one of the things to note is that the Extreme production report, where they list every MSG that they produced, includes a VIN number.
Which exhibit would that be?
I'm looking for that. It is Exhibit 25. It's 52 pages, and it lists every MSG that they produced, including a VIN number, a date, a description, whether or not it's been shipped. There's a lot of different information within it. And then let me know when you have that open, and I can also walk you through the related report that we prepared.
It's open, please proceed.
Okay, so seeing that information within that exhibit, what we did was we took that, and what I'm going to have you look at next, if you would please, is Exhibit 9, which is what is referred to as the SMS database. Now, just to remind you, the SMS database was the database that was created by the trustees team to track and record all of the MSGs that they located as they were found, and then ultimately that was reported to the court, and then it was also used as a control to record those that were sold at auction and liquidated. So the SMS database also includes a VIN number, and it identifies the fund that owned the MSG that was located. Okay, are you seeing that?
Yes.
Okay, so yeah, we've got the fund number, we've got the location that it was found, we've got the VIN, and there should also be, I think, a model if it's available within that. So taking those two reports, what we were able to do is putting those into Excel, we were able to do a VLOOKUP and establish, with respect to the SMS database that recorded where these units were found, we could then cross-reference the Extreme report with SMS to determine the units that Extreme manufactured that were located outside the states. We then took that a step further and said, okay, well, since we know the fund to which these are associated with, we tied it into the audit. And we were able to establish that the number of units that we identified that were found in relation to each fund in the audit reconciled exactly to the number that we came up with as to the MSGs for each fund that's addressed in the audit. We then summarized that in Exhibit 5. And let me, if you can, I can walk you through that here briefly. And Exhibit 5, by the way, has the detail of what we just looked at within it. It's It's 1,075 pages, at least in PDF form. And so the reason why it's so long is because it includes the extreme data, right? And it includes the SMS data. And then for each fund, we then did a VLOOKUP for that particular fund to establish what units belong to it and where were those units found and were they manufactured by Extreme, okay? So going to the version I have at the moment is not Bates stamped, I apologize, but it's the second page of Exhibit 5, which should roughly be Bates page 72 or 71, but it's titled Potential Measure of California Tax. And then I can show you what we got, how we, what our conclusion was here, and then I can walk you back through this and help answer any questions you may have. But ultimately, this lead schedule established that there were 3,879 units that were found in California or found outside of California and originated from California, okay? So if we determine that the unit was built by someone other than Extreme, which I think we had to do this by process of elimination. I don't believe we had, for example, data from US Tower that allowed us to say, okay, well, that must have been built by US Tower. So if we couldn't tie it to Extreme, we just made the presumption that it originated from California. So even if it was found in Florida at a speedway, we said, okay, fair enough, we'll call it taxable. Again, in theory, that transaction could be an exempt sale in interstate commerce. We don't have the evidence to support that, so we're not seeking it. But at a minimum, to the extent we think we can and have supported, these units never entered California, that the law supports, tax doesn't apply. We think an adjustment is warranted. And by extension, appropriately puts more availability to funds within the estate, which allows these investors to get a little bit more of their money back. And that's the goal here. In any event, we took that number, we multiplied it by the average consideration established by CDTFA's audit staff of $44,946, and we multiplied those two numbers to come up with what we call potential measure. It's potential because it could be TPP and all of this goes away. Is why we phrase it that way. And we subtotaled it by audit period, multiplied it by the rate that is from the 414M transcript of returns for each period, and that's how we got computed tax. Now, if you want, what I can do is if you go down to the next page, what we've done for each fund is summarize the process. And I can walk through that and even go into the detail of the actual worksheets that this comes from, if you would like me to do that.
I think I'm okay, but co-panelists? No.
Okay. I'll just end with this. If you spend a little bit of time, like all worksheets, a lot of times you look at it and it's like, what the heck is going on in that? If you spend some time with this and you sort of work your way back, or, in the alternative, go to the back and work your way forward, these descriptions that address each fund, I think make it pretty clear. It specifically references the audit schedule that you can reconcile the number that we're seeing to. So in other words, we come up with, on Fund 6, we've come up with 128 units found for Fund 6. And we're able to go to the audit and say, okay, well, the audit confirms that there's 128 units for Fund 6 on R3 12A-1. And then the analysis supports that 71 of those 128 units that are being assessed for Fund 6 were located in Nevada. And we think more likely than not have been established to never have come into California. And then you can go on down the line, and if you add them up for each of these, you get to 1,051.
Thank you both.
Absolutely.
All right. Okay, so I have also a few questions. So the MSGs, there are several models at issue, is that correct?
Yes.
My understanding is there's 3 models, or are there more models at issue?
Well, that's a good question. I mean, if you look at, let's see here, Exhibit 28, hold that actually. Exhibit 26. So some of this, Judge Wong, came to light with the questions that were recently asked by the panel. So some of this is somewhat new to me. But generally speaking, since I've been involved with this case, I've always understood that there's variations. So you're going to have a base model that will have the panels, will have batteries, inverter, things of that nature, right? And then, that rolls up to, I think the model with all the options basically is going to be those items I just described, in addition to a generator, a 100-gallon gas tank, and lights. Okay, and so the variations within that, if you look at Exhibit 26, at least suggests that there's 4 or 5 models that have existed with variations of that. So, maybe you have the lights without the generator, or the generator without the lights. Well, that's essentially 3 variations there. For all
Okay.
intents and purposes, they all did the same thing.
Okay. So I noticed that there's based on Bates number 1773, that's not exactly, it's not marked, but it lays out 3 models. The first model is XC5, the second model is XC10, and the third model is SCT20. Do you see that?
I'm getting there, but I'm familiar with what you're referring to because I've looked at this.
Okay, and it looks like these 3 models, they have different gross vehicle weight ratings.
Yes.
The first one says 3,400 pounds,
Mm-hmm.
the second 5,200 pounds, and the third is 8,400 pounds. Did each of these models have a different trailer? At the beginning of your presentation, we talked about trailers manufactured by Carson Trailer, and you had pointed us to the car hauler trailer, I believe. Did they use different models of trailers from Carson Trailer for each of these 3 models? Or were they all the same model and they just had different equipment on them?
I think the answer is yes to both, and I'll explain that. So if you look at Exhibit 10, and you don't necessarily have to look at it right now, but Exhibit 10 is the trailer purchase reports. Now that includes a report generated by Carson, and then at the end it also includes some information from Forest River. Now Forest River had 500 units that they produced. They refer to the trailer as a chassis. It sounds like theirs was more of a ground-up manufacturing process. Whereas to the extent you're using Carson, they're essentially DC Solar would buy those from Carson and then send it to a manufacturer, like Extreme, to complete the manufacturing process. Ultimately, we view the trailer frame, the trailer as really just a part. I mean, frankly, if there's going to be a component part, our position is that the trailer was a component part of the MSG, not the other way around. Because the power production was the primary purpose of the product. It's the true nature of the product, if you will. But sorry, I'm getting off on a tangent there. So as you'll see, if you look at 10, there's different models. There's 2 models that I see, and I looked up those 2 models, and essentially, I think there's a variation in length is how they vary. And then also, if you look at the exhibit, page 1, where you got the XC5, XC10, and SCT20, the dimensions, I think, establish what trailer was being used. For the most part, I mean, they have a transport dimension and a deployed dimension. And of course, the transport dimension is one thing because everything had to be folded in and sort of locked down, turned off. And then deployed, panels are out, it's a little bit different. For the most part, you would anticipate to, get a feel of the size of the trailer from the transport dimension, I would suspect, because again, everything's folded in, retracted, and so forth. And you can see that there's different sizes there. So they had some different trailers.
Do you know how much, so you mentioned there are potentially 2 different models of trailers, if I understood your comments correctly. Do you know what the unladen weight of each trailer was? I think this was one of the questions that the panel had posed after the pre-hearing conference. And I believe in your response, you had indicated that Ms. Lovato was not aware specifically of what the unladen weight of the trailers was. I just wanted to get it on the record to see if you were aware of what the unladen weight of each trailer used for the MSGs were.
Yeah, I did some research on that, and I thought I actually incorporated the answer, and it appears that I did. So, according to my research, and there's a site, usacargotrailersales.com, that provides estimates for weights of unladen trailers. And we looked at a 6x12 all the way up to 8.5 by 22, based on what we saw in these reports to capture what we believe would have been the range. And it appears that on the smaller side, it's 1,200 pounds. And on the upper side is 3,400 pounds.
Sorry, was that in the, was that in your exhibits? I might have missed that. Where was the?
That was in the response, the pre-hearing, the response to the pre-hearing questions at page 3.
Got it, okay. Okay, I see it, thank you. Okay, for the MSGs at issue, do we know of the breakdown between the models, like the smallest model, there were this many at issue, the middle model, there are this many issues at issue, and then the third model, there are this many units at issue?
We can certainly establish that based on the evidence in the record. I think there's a,
Okay.
well, for example, the extreme build report segregates between hybrid and base, okay? Now, that's only a portion of the total. And truthfully, I don't know if it would be fair to take that segregation and project it to what would amount to be like, the other 4,500 that existed. Well, Christina's reminding me that it's on the SMS database. So you should be able to go to the database
Okay,
and then sort it by model number
okay,
and basically have that exact number.
okay.
So, bingo.
The reason I'm asking is just because if it comes down to we have determined that some models are taxable, some are not, or some are MT, some are not, that breakdown could become material. So,
Understood.
another question I had was, you had made the argument, or you had gone to the DMV, and they provided an opinion that the MSGs function as special mobile equipment. Were they registered as special mobile equipment with the DMV?
You know, that's a good question, and I don't know the answer to that. I'm not certain where I would find the answer. I haven't seen anything that would lead me to it.
Okay.
I will say that obviously we consider that to be meaningful, which is why we sought it out and why we submitted it. We also think that the DMV recommendation is well supported. I mean, it's not like we consider and say, well, geez, that doesn't make any sense. I mean, these things carry cargo all over the place. They don't. They're not self-propelled, which is part of the test. They're not for use in transporting persons or property, and they're only incidentally moved over the highways. And that fits like a glove in this scenario.
CDTFA had mentioned I believe in their response, they had referenced this is Exhibit 3. This is the MSG technical guidelines, and it referenced, let's see, this is page 52, I believe, Bates 52. Yeah, it's Bates 52. In the middle, it talks about important material found in the job box, and it talks about registration. And it references a laminated copy of registration can be found in the job box. So this seems to indicate, at least from CDTFA seems to suggest that this indicates that the MSGs were registered with the DMV.
And I will just say that it's my general understanding that there was registration with the DMV.
Okay.
And that, they were at least titled with the DMV. And ultimately, our position on that is that registration isn't dispositive of the product. That, for example, you could have something that should be registered that's not. And if it's MT, it remains MT. You could have something that's not MT that's registered. Wouldn't make it MT. And I think the same would hold true for special mobile equipment. I would venture to say there's probably a lot of people walking around that are awfully ignorant about that, as I was before I got involved with this case, and may go and register something like an MSG as just a standard trailer, when in fact it qualifies, we think quite clearly, for a different registration. So I think it's certainly fair to look at all the circumstances and weigh them appropriately, but we
Right,
just.
Okay, so just the meaning of being registered with the DMV as just a vehicle, does it mean, so it would be capable of being used on the highway and transported long distances because it was registered with the DMV? Not to say that it was, but just does the fact of registration with the DMV suggest that?
Well, I guess you would have to understand how it was registered, I think, to answer that question. I think it was registered as special mobile equipment that then, the conclusion that may be drawn from that is that it was incidentally used over the highways, which is how special mobile equipment is defined.
So it was registered as special mobile equipment, or was it just registered as a regular transportation equipment?
I don't know the answer to that. I do generally know, through having been involved with this case and having read a lot of different things, that there was discussion around registration, and frankly, where it came up, I think it may have been within the criminal context. that there was a process that was established where they were covering VIN numbers with false VIN number stickers that they had ordered from a local printer, and that those were used for purposes of essentially registering or at least titling the units with DMV more than once to give the impression that they had more units than existed. Now it didn't speak to whether or not the titling or the registration or whatever did exist was of a standard vehicle, within the confines of a trailer, or if it was set up as special mobile equipment. I have not seen anything to that effect.
Okay. So I found a picture in Exhibit 32. It's Bates 2042. And so it looks like it's figure 27. It says power station deployed. It looks like there's a license plate there. The quality is not great. Does that suggest that it was registered with the DMV, not a special mobile equipment, but just as regular transportation equipment?
I don't know the answer to that.
Okay, that's fine. Okay, that's fine.
This is the photo that you're looking at is the photo of what appears to be the deployed MSG at a ball game that says "Get Charged Up Power Station." Is that correct?
Yes, that's correct.
I mean, in full disclosure, this is just speculation, but my assumption is that if you register something as special mobile equipment, you will get a plate.
Okay.
Just as you would as if you registered as a standard trailer.
Okay. So it could be, I guess your point is it could be special mobile equipment registered, but the plate is not clear enough for us to make that determination, or?
That's correct.
Okay. Sorry, let me just double check any further questions I had.
I will just add briefly
Sure.
that, and this is a little off topic from the question, but this image of this particular unit that's deployed at a ball game, I think, provides a good view of the rear of the trailer. And the fact that there's, as part of the manufacturing process, that there's bars, and in this one happens to be wrapped with, some logos and telephone numbers and so forth, some marketing material essentially, and that it's set up such that you couldn't receive property onto it from the rear, which again goes to it being incapable of transporting property.
Okay, thank you. And I had a question about your earlier argument that, just focusing on the trailer itself, the trailer from Forest River and Carson trailer that had been, for lack of a better word, adapted to take on the solar equipment. You'd indicated that adaptation transformed the trailer legally into something that's no longer a trailer under the vehicle code. Is that correct?
That is correct.
So what modifications were made such that it was no longer legally a trailer under the definition of the vehicle code?
Well, I appreciate the question. Number one, we provided the MSG parts list as Exhibit 29, and perhaps we can just go to that. Okay. My computer doesn't doesn't run very fast. So these are all the various parts that exist. And if you add up the price each and the extended price, which doesn't appear to be done here, but it's approximately $50,000. Now, one of these parts, and I'll see if I can find the line item, but one of these parts is indeed the trailer, and it references Carson. Looks like it's line 17.
Yep.
Okay, so it's got a price of $3,400, right? I mean, this goes to, we believe this goes directly to our viewpoint of this, which is that it's not so much that you look to the manner of manufacturing. Because if I understand things correctly, and I may not, so I apologize if I'm getting this wrong, but essentially one viewpoint is, well, hey, let's take a look at this completed trailer that was purchased, okay? And let's figure out if that qualifies or is excluded as MTE. And if it qualifies as MTE, it's always going to be MTE. And everything you attach to it will also be MTE. We just don't believe that that's consistent with what the law says, where you only include in MTE property that is for use in transporting property. Not necessarily even capable. I think Adler teaches us that. I mean, certainly tanks are capable of transporting property. I mean, it's quintessential MTE. It's just that it wasn't for use. But taking that further, in this case, as the photos have shown, you know, we started with a flatbed trailer. Ms. Lovato and had pointed out to me as I was talking that U.S. Tower, which was a manufacturer based out of California, they manufactured a lot of these. They also took the approach that Forest River did and essentially built it from the ground up. They didn't buy an outside trailer. They constructed it all together. You know, my point, and I'm going to answer your question here, but my point is that shouldn't make a difference. That if you start with what is otherwise a trailer of some type, whether or not it qualifies for MT or not, if what you end up with is a product that is incapable of transporting property, then at least according to the definition in the vehicle code, it's not a trailer. It's not legally a trailer because in order to be a trailer, it has to be capable of transporting persons or property. That's the legal definition.
Would the solar equipment qualify as property that the trailer is transporting, that it's being attached to the trailer itself?
I don't believe so. Ultimately, this is where there seems to be sitting on both sides of the fence going on, and that, of course, CDTFA has historically said that, hey, look, if you put something on a trailer that you can dismount and use functionally off the trailer, we won't call it MTE, okay? Well, in this case, the argument is that these are integrated, permanently attached, and I don't think we need to really just use words there. I think the documents speak for themselves. If you look at the parts list and you look at the photos, starting with just a base flatbed trailer, what you start with, and then you add your welding steel, your bolting steel, you're adding these parts. The steel is specifically designed to accept the solar panels and allow them to rotate. The framing within the unit is specifically designed to house the battery cages and on down the line. And at the end of that process, again, we think it's dispositive that if at the end of that process, that product is incapable of transporting persons or property and was not for use in doing that, the rest doesn't matter. it's not MTE. And we don't go through and we don't analyze, well, it started as a trailer. And that's what Adler, the point earlier is, look, Adler doesn't have to get there because of the nature of the products that they were using. But the nature of this product truly is one that has converted from one thing into another. And I understand there's an analysis to be done to determine whether or not the trailer actually qualifies within a specific trailer or is excluded and so forth. And it's possible that that analysis could reach a conclusion that says, well, this trailer was capable of being hauled by a passenger vehicle, therefore it's not MTE. We're not going to worry about what's attached to it. But if we do conclude, well, wait a second, this is a qualifying MTE trailer, then the next question is, well, are we really going to say that everything attached to it naturally becomes MTE? Because in order to do that, we do have to follow essentially the line of reason that says that all TPP is a component part, which if you read the language, it identifies TPP that is. In other words, there's also TPP that is not a component part. And then it addresses TPP that becomes a component part. So that means that it starts out being something else. So we think the end product is what matters.
Okay. Last two questions. So the technical manual in Exhibit 3, it does refer to a trailer. Is that of any significance? Like, I'm talking specifically about page Bates 30. The heading says trailer, and it has a picture of the MSG. Is that of any significance?
I really don't think that it is. I mean, ultimately, the use of the term trailer in marketing material is general use. I think, a discussion that I would have with any individual, of course, today might be different than it was a couple of years ago in this regard, at least for my thoughts process. But, I mean, for all intents and purposes, you look at the unit and you may think that there's a trailer aspect to it. Sure, fair enough. But I think within our context, the appropriate viewpoint is what the law says. Okay, not common knowledge. Where we have definitions, I think those have to be used. And in this case, trailer is defined, right, under the vehicle code.
Okay, thank you. And then the last question I had, it goes to the definition of mobile MTE in 6023, and actually it goes to the exclusion from that definition for passenger vehicles. The law was passed in 1971, went into effect in early 1972. Passenger vehicles, the technology involving passenger vehicles has developed since then. What qualified as a passenger vehicle then is the same as what qualifies now. Are we looking, I don't know if their compact cars existed back in the early 1970s, apart from maybe like the Volkswagen Beetle. I don't know if their compact pickup trucks existed at that time, but do we take an originalist position and figure out what passenger vehicles meant in 1971 as far as this exclusion goes, or do we take into account passenger vehicles today, passenger vehicles at the time of the liability period?
Yeah, it's an interesting question. It's one that I've battered around in my head. I mean, here's the thing: is practically speaking, I drive a truck, and I like to joke around that I haul around my briefcase sometimes in the back of it, but otherwise, it's a passenger vehicle, and I'm transporting persons. I think one of the evolutions that exist, and I'm not able to personally speak to those timeframes, but my understanding is that historically trucks were truly used more for commercial purposes. You didn't have as many people as you do today using a truck for a passenger vehicle. So that's at least one practical thing that comes to my mind in this. Is as far as the application and the analysis, I think the appropriate approach is to simply use the definitions as they stand. I don't know that they need to be modified And I think it's appropriate to use the vehicle code sections as they're written.
Okay, thank you very much. That's all the questions I had right now for appellant. Let's go off the record really quick. Did you want to break now, or did you? Okay. We're going to take a 10-minute break, and then we're going to turn it over to CDTFA. I think is more of a better natural breaking point. So let's come back at 11:45. Thank you. Ms. Alonso, are you ready to go back on the record? Okay. Let's go back on the record, and now we'll turn it over to CDTFA for their presentation. You have 40 minutes.
Thank you. Good morning. The issue today is whether adjustments are warranted to the measure for use tax due on mobile solar generators, or MSGs. Let me keep trying this. No. Okay. Appellant, DC Solar Solutions, was in the business of manufacturing, leasing, and retailing mobile solar generators mounted on trailers for off-grid purposes, such as concerts and construction projects. As demonstrated in the Department Exhibit I, the MSGs at issue consist of a trailer, frame, battery, inverters, spider box, job box, charge controllers, breaker boxes, and solar panels. Additionally, as shown on the department's Exhibit I, the MSGs weighed from 3,400 pounds to 8,400 pounds and used a pintle hitch for towing. Appellant's liability resulted primarily from its failure to report or pay use tax on its taxable sales of MSGs during the liability period. California imposes sales tax on a retailer's retail sales in the state of tangible personal property, measured by the retailer's gross receipts, unless the sale is specifically exempt or excluded from taxation by statute. All of a retailer's gross receipts are presumed subject to tax, unless the retailer can prove otherwise. A lease is a temporary transfer of possession and control of tangible personal property for consideration. For purposes of the sales and use tax law, a taxable sale or purchase in this state includes any lease of tangible personal property for consideration, except a lease of MTE. Revenue and Taxation Code 6023 defines MTE as equipment such as trucks, truck trailers, dollies, bogies, chassis, reusable cargo shipping containers, and tangible personal property which is or becomes a component part of such element. Regulation 1661, subdivision A1, states that MTE includes equipment used in transporting persons or property for substantial distances, and tangible personal property which does not independently meet the definition of MTE, but which, by nature of its attachment to MTE, becomes a component part meeting the definition of MTE. With respect to leases of MTE, the sale to the leaser is the retail sale, and the leasor is the consumer of the equipment. Thus, either sales tax applies to the sale of MTE to a leasor, or use tax applies on the leasor's use of the MTE in this state for leasing purposes. The use of MTE purchased without payment of tax is limited to leasing the MTE. The purchaser may elect to report and pay its use tax liability on the fair rental value of the MTE. Such election must be made on or before the due date of the return for the period in which the equipment is first leased. Otherwise, use tax is imposed on the leaser's entire purchase price for the MTE. When a timely election to pay tax on the fair rental value of MTE is made, use tax must thereafter be paid with the leaser's return for each reporting period, measured by fair rental value, regardless of whether or not the MTE is thereafter located within this state. Here, the mobile solar generators are affixed to trailers, which are statutorily included in the definition of MTE. Further, the type of trailers used, as shown in Appellant's Exhibit 10 and Exhibit 28, were flatbed trailers that are both designed for and capable of transporting the MSG's substantial distances. In addition, Appellant's Technician Guide, the Department's Exhibit I, does not place any constraints on the transport and use of the trailers. Appellant repeatedly contends that the MSGs are not MTE because they do not transport persons or property. This argument misses the mark. Here, appellant purchased trailers designed for carrying persons or property substantial distances. It then permanently attached component parts to the trailer. Those component parts become part of the MTE. The trailers then transport tangible personal property in the form of solar panels and related generation equipment. Thus, the entire MSG qualifies as MTE. This is consistent with annotations 335.0012 and 335.0049, as well as other citations cited in the briefing for this case. These annotations demonstrate that when component parts are permanently attached to MTE, they become part of the MTE, and is also consistent with the OTA's Adler Tank Rentals presidential opinion. We would also like to point out that the MSGs were in fact equipped with a job box, which would allow them to transport additional TPP if appellant's customers so desired. Thus, the MSGs meet the definition of MTE under the applicable law because they both transported the solar equipment that was permanently attached to a trailer and because they contain a job box that could transport additional tangible personal property. Turning to the issue of whether the MSGs were designed for towing by passenger vehicles, we first want to reemphasize that pursuant to Regulation 1661, Subdivision A, component parts are included in the definition of MTE, and the component parts become part of the MTE. When appellant sold or leased the trailers, it was always along with the permanently attached solar generator equipment. The trailers were towed with this equipment and used at different job sites, while still attached to the trailers. Accordingly, the trailer and its component parts are all defined as MTE. And the total weight of the trailer and its component parts, the MSG, is what should be analyzed when considering whether they were designed to be hauled by passenger vehicles. Turning to the language in both the statute and regulation regarding the types of trailers that are not MTE. Both the statute and regulation state that trailers and baggage containers designed for hauling by passenger vehicles are not included in the definition of MTE. Given that the only example the statute and regulation provides is baggage containers, and that the type of trailer must be designed for hauling by passenger vehicles, it can be presumed that the trailers they are referring to are lightweight trailers, likely weighing 1,000 to 2,000 pounds or less. These are the type of trailers shown in the department's exhibits J and K that can be towed by nearly all passenger vehicles, like the Toyota Corolla and the Honda CR-V, which is an SUV. Their towing capacity is up to 1,500 pounds, as shown in our exhibit K, I believe. The trailers sold and leased by appellant, as stated before, weigh substantially more than the lightweight trailers and baggage containers contemplated by the statute and regulation. Next, the argument that the trailers are not MTE because it is possible for a passenger vehicle, such as an SUV, to haul one of the trailers at issue is equally misguided. The mere fact that it is possible for a large passenger vehicle to haul one of the trailers does not mean the trailer was specifically designed for hauling by passenger vehicles, as contemplated in the statute. In this respect, we note that large passenger vehicles, such as SUVs, have a towing capacity similar to pickup trucks, which are defined as MTE by Regulation 1661, Subdivision A1. Furthermore, the MSGs are not unlading trailers, such as a U-Haul trailer, which are used by consumers to transport property from one place to the other. The MSGs are loaded with commercial component parts, are not the type of trailers Regulation 1661 excludes from the definition of MTE. Accordingly, the trailers and their permanently affixed component parts are MTE, and the lease cost of the entire mobile solar generator is subject to tax. Turning to the audit contentions, we first note that it's appellant's responsibility to maintain and make available for examination on request all records necessary to determine the correct tax liability. This includes bills, receipts, invoices, or other documents. If appellant's records are proven unreliable or insufficient, it is appropriate for the department to compute and estimate the taxpayer's liability by alternative means, And if the department is not satisfied with the accuracy of the returns filed, it may base its determination of the tax due upon the facts contained in the return or upon any information that comes within its possession. When a taxpayer challenges a determination, the department has the burden to explain the basis for that deficiency. Where the department's explanation appears reasonable, the burden of proof shifts to the taxpayer to explain why the department's asserted deficiency is not valid. Except as otherwise specifically provided by law, the burden of proof is upon the taxpayer to prove all issues of fact by a preponderance of the evidence. That is, the taxpayer must establish by documentation or other evidence that the circumstances it asserts are more likely than not to be correct. So here, the audit was complicated by the undisputed fact that appellant was running a fraudulent multi-billion-dollar Ponzi scheme for which his company's executives were criminally prosecuted and jailed. As part of this scheme, appellant intentionally misrepresented the amount of units it sold to its customers. As a result, the typical books and records the department would expect to be provided were not reliable. Upon audit, the department determined that appellant sold the MSGs for $150,000 per unit, and based on sales contracts in the general ledger, determined that appellant sold 2,754 MSGs for approximately $410 million during the first liability period, all of which it claimed as non-taxable sales on its returns. For the second liability period, appellant reported on its returns total sales of approximately $1.5 billion, all of which it claimed as non-taxable sales. The department determined that all these sales were taxable sales of MTE. With respect to the contract purchase price, we know that the department did not include the total purchase price for every transaction assessed in the audit. Where there was evidence of contracts where appellant was not paid in full by the purchaser for units it did produce, the department used lower average prices. However, for contracts where appellant was paid in full for units it actually delivered, according to the contract, or instances where appellant received more consideration due to not producing the total units under the contract, the department used a purchase price of $150,000. This is shown in Exhibit H, page 4172. On September 30th, 2022, based on additional information provided by appellant after issuance of the NOD, the department completed a re-audit, which reduced the deficiency measures for the second liability period from approximately $1.5 billion to $502 million. Another re-audit in 2023 reduced the deficiency measure for the first liability period to approximately $84 million, and the measure for the second audit period to approximately $252 million. Finally, after the most recent re-audit of the second liability period, appellant's liability measure for that period was further reduced from approximately $252 million to approximately $222 million. The department has been reasonable and rational in its approach to the audit. The department used the SMS report provided by appellants, which is most recently shown in Audit Schedule R4 12A 1A and attaches Exhibit H, page 4172, to determine where the units were produced and where they were eventually found. The department accepted this documentation as it was the only reliable information available. The challenges the department faced were tremendous due to appellant's criminal behavior. The department ultimately reduced the total measure by approximately $1.6 billion. Appellant has in no way met its burden of proving that further reductions should be made to the taxable measure. In short, the department has conducted a series of re-audits to remove from the measure of tax units that were not produced, even though appellant received payment for them, and units that never entered this state. Regarding the MSGs found out of state, that appellant contends never entered California. We note that the law presumes that all of a retailer's retail sales are presumed subject to tax and places the burden on the retailer to establish any right to exclusion or exemption. Pursuant to Regulation 1620, a retailer must provide proof of out-of-state delivery pursuant to the contract of sale. Here, the available contracts show that title passage or delivery occurred in California. Thus, they are properly included in the measure of tax. The department has already made every effort to exclude any units where sales did not occur in this state. The fact that some of the units may have eventually been located outside California does not establish that they were not ever located here, especially considering that the contracts either called for delivery or title passage in this state. We further note that the SMS report shows that only 5 units were found located at Extreme Manufacturing. All right. Finally, turning to the negligence penalty imposed on the second liability period. Under the law, if any part of the deficiency for which a deficiency determination is made was due to negligence or intentional disregard of the law, a penalty of 10% of the amount of the determination should be imposed. Here, the negligence penalty was properly imposed because the department informed appellant during its first audit and prior to the commencement of the second liability period that it considered the MSGs to be MTE, and therefore appellant's MSG sales were taxable retail sales. Yet appellant continued to claim its MSG sales as non-taxable in its sales and use tax returns filed for the second liability period. If appellant disagreed with the department's position, it should not ignore the department's advice. It should have begun reporting and paying tax in accordance with the department's instruction and then file claims for refund stating it disagrees with the department's position. And I want to briefly provide a response to the information from the DMV. This response, based on reading it, was from the DMV was just informational, and there's no confirmation in that response that they specifically examined and found the trailers at issue here were special mobile equipment. Therefore, no adjustments are warranted to appellant's liability, and this concludes my presentation. Thank you.
Thank you, Mr. Smith. I'll now turn to my co-panelists to see if they have any questions for CDTFA, beginning with Judge Turner.
My first question, I think the taxpayer answered it, but I'll ask them to reply as well. When do we make the determination of what is MTE and what is not? From the time in which parts are manufactured. In this case, we have maybe a hitch, a frame, platform, a box, wheels, the attachment of batteries, solar units. At what point during a manufacturing process, or it's not during the manufacturing process, but at what point, up to the point of delivery, do we decide or make a determination of whether or not that property is MTE or not?
I mean, we make the determination if that property becomes a component part of the trailer, of the underlying MTE.
Well, recognizing any property is simply parts. The question is, at what point do those parts, when assembled together, are determined to be MTE or not?
I think we would look at the fact that, generally speaking, we contend that we have trailers here that had various parts that were attached to them, which also becomes part of the MTE. Whether or not we would consider like these parts as component parts per the annexations, and I think Adler Tank Rentals, we look at the fact that they're sold with the parts attached, they're transported with the parts attached, and they're used with the parts attached at the end of the day. Like, they're not really coming off. So here, for this case, looking at the first prong of Adler, I would say you have a trailer, which is included in the definition of MTE, and then you look to see if any parts that come with it always stay on the trailer. If they're not being removed, they're essentially part of the trailer.
Okay. Second question, at the time at which we are evaluating whether tangible personal property is MTE, are we evaluating whether or not the property is designed for a purpose, capable of being used for a purpose, or actually used for a purpose that constitutes MTE?
The equipment here at issue is literally being transported mobily and then used on site. If you look at the annexations and such, an MRI lab that's attached to a trailer gets transported as equipment and then used at the site. Water pressure machines that are permanently affixed to trailers are transported and then used at the site. I hope that answers your question.
Yeah, I'm not sure you're parsing out the question, which is whether something is MTE or not. You have items that are specifically identified in 6023. And for those items which aren't specifically identified, we sort of you look at 60064 where it says for use transporting persons or property. And I'm trying to figure out whether or not for use constitutes a question of design to purpose or capable of or actually used for a thing. That's all. So
Yeah, I mean, again, just pointing to Adler and the annexations, I think our position is that a trailer is designed to transport, usually tangible personal property or perhaps like livestock, not usually people's. So that is MTE. And then when you have parts that are put on it permanently and used in the way I just talked about, that becomes part of the MTE as well. I think the trailers here were designed to transport solar equipment and other affixed parts and then be used when they reach the site and then capable of being transported other places as well.
taxpayer have any desire to reply to the same question? Sorry. No. My questions are.
I appreciate the opportunity. I was sort of deep in thought with what was being said there. But I think the question is the inquiry whether it's designed, capable, or for use? Is that correct?
Yeah.
Okay. And I think it's a good question. It's an interesting question. And one that I've given thought to. I think Adler speaks to it as well. I mean, ultimately, these analyses have to start with the plain language of the code, right? And it uses the term for use. It very easily could have said designed, right? I mean, if the legislature wanted to use that language, it wouldn't have been difficult to put it in there. And I think that could have made a difference. So using the for use term and carrying that through, I think one would reach the conclusion that, like in Adler, where you have something that's designed to hold property, and presumably could move property, maybe if it wasn't hazardous. I don't know the facts of Adler all that well. I don't want to speak to it as if I do. But just practically speaking, a tank that's attached to wheels, it's designed to hold property. Presumably, if it wasn't hazardous, they could transport it. I mean, that's quintessential MTE in my eyes. It's industrial level, and I think it goes to the legislative intent. It was designed, in essence, to transport property, but it wasn't for use in transporting property. And that's why the conclusion that had to be reached there is that it's not MTE, because it's not for use, because of the directives that exist within that particular company, within that particular transaction. I think probably likely impacted by it being hazardous waste. While, as I understand it, as it's constituted, although designed and capable of transporting property, because it wasn't for use in transporting property, it was found not to be MTE. So I think the plain language, coupled with the analysis of Adler, supports the notion that what it's used for, what's it placed into use for, and then I'll just briefly add, having thought about this again myself, is I think the language was intentional in that if you sell something that otherwise would qualify as MTE, and we have to take a step back to some degree and recognize that the idea was that this approach was something that the industry wanted. It's the railroad industry, the transportation industry wanted. They're the ones that sponsored this legislation. They wanted their property to qualify. And their property initially would qualify if it was, quote, constantly moving in interstate commerce, okay? Now that essentially was changed to transporting persons or property, but that's the genesis. So ultimately, it wasn't just the nature of the property, it was indeed the use of the property that formed the law that we're dealing with. And taking that a step further and applying the language for its plain meaning, I think it's possible that you could certainly sell a product that qualifies as MTE, and if it's not placed into use for transporting persons or property, it would not qualify for the classification under the law, which does not create an exemption. It just merely establishes how tax will apply. In this particular case, what it does is it triggers a different exemption, that being sale for resale, which there's a stipulation for. But it's just a matter of deciding how the tax will apply, ultimately.
Thanks.
Yes.
Question, I guess, for both of you as well. Are all trailers MTE by definition?
I mean, no, it says specifically that trailers and baggage containers designed for hauling by passenger vehicles are excluded.
Oh,
So-
I apologize. So,
Okay.
thank you, good clarification. So other than the exclusion in 6023 for trailers that are designed to be hauled by passenger vehicles, are trailers by definition MTE? Meaning, do we start with the assumption or the conclusion that if it's a trailer, it's MTE unless it's excluded?
Yes, we do.
Yeah,
Yes, sir, that's our
That's our position.
understood. Thank you. Is there does the department dispute that there are a number of, whatever the number is, of these MSGs that are located in Nevada?
In looking at the SMS database that the appellant's attorney referred to earlier, they have a number of locations that they were of items that were found out of state. Some of them included Phoenix. There's a raceway in Phoenix, Daytona International, also Las Vegas Speedway. So there's definitely quite a few in Nevada, but there are also others that are found at other out-of-state locations that are included in his listing.
I guess when a taxpayer is making a point that part of that equipment is being included in the taxable measure, is that something you dispute factually, or?
It's our understanding that, like, with respect to the units Mr. McClellan is talking about, that we excluded a lot of units that we found evidence where they never entered this state at all. We allocated some units that were eventually located in Nevada and other areas because the contracts we saw called for delivery in California. We don't have evidence that they were pursuant to the contract of sale, shipped out of state, or anything like that.
Or were never delivered? It's a factual question from your perspective.
Yeah, it's a factual question, and again, like, I want to note that we had limited documentation on what we could look at to actually determine the liability in this case. So we're not even sure this is a ultimately correct representation of everything that was produced, and until we were able to see complete records and know what was going on, we're not going to give them further benefit of the doubt and just assume that because it was eventually found in Nevada when the contract called for delivery in California that it never actually entered this state. And a lot of the documents we see say shipped.
Thanks, I appreciate that.
Yes, sir.
Yes, sir.
Yeah, I would just like to respond to that. The department has alluded to the notion that they didn't have what they needed to make a determination or perform the full audit. Included as an exhibit 19 are audit verification comments, both of which explicitly state that the records were sufficient. I worked with the last auditor directly, Randall Chagtigney. I'm not sure if I'm pronouncing that right, but in any event, very nice guy, good guy to work with. And he actually provided me with the vast majority of the documents that I have to this day. You know, they had a trove of documents from the taxpayer. And then in the re-audit process, as it pertains to this particular issue, and I respect the department representative that's saying this, I think that there's a disconnect between what actually transpired and what exists in the way of documentation and maybe his understanding, and I'll explain that here briefly. One of the things that we initially set out to do, first and foremost, after we got involved with this case, was to establish the number of units that exist, okay? And he said, well, you know, the department representative said that they can't be sure about the number. I think we can, and I can explain that. And we didn't necessarily incorporate all this into the record because this is the first time I'm hearing this, by the way. I thought this was a well-settled issue with CDTFA. Here's the reason why. Is in order to establish the number of MSGs built, we went to Carson Trailer, we went to, and we went to Forest River. Because we know that a component part of an MSG, and that's a slippery slope using those terms, but that a component part of the MSG is the trailer frame, right? It had to have a trailer. Without it, you know, it's not an MSG. It's at least not mobile. And so we accounted for all the trailers. We counted them. And when you count up the total trailers purchased, as you can from that documentation, and as we incorporated it into our analysis, you can establish the base number. Okay, this is the most we're gonna have. And there were some bare trailers located that were never manufactured. And then we cross-referenced that with the SMS database and put all that together and worked with the audit staff, Ellis Hugg, the then principal auditor at the time, where we agreed. You know, we came to an agreement. Okay, yes, this is accurate. And, you know, by the way, we've got criminal complaints, pursuits, where they've documented that not all the units have been produced. We've got the Melissa Davis report that's in the record. I shared the pages. It's in CDTFA's exhibits. I shared the pages previously, and I can give those to you again if you want me to. But that declaration is very, very thorough. And she makes it clear that a similar number that we've identified, actually a number less. I want to say she concluded that 6,000 MSGs were produced. Our thorough investigation revealed that it was approximately 7,200. That includes the first 2 quarters of 2015 that are not part of the audit periods. And that ultimately the SMS database was found by the audit staff to be so reliable that they use it for the audit. You know, it's a document that's prepared by a third party. It's being presented before the court for validation of what exists. And then ultimately, these units have to be put out to auction and sold with a trace of the money and so forth. So as to the number of units, it's very well documented. Now, as far as the contract provision, again, fair enough. You know, and that's, I agree with what the department's saying there. That they allowed adjustments for units that were located outside of the state. The exception, and I don't know if this is universal because I haven't looked at it, every one, and there's a lot of layers to this onion once you start peeling it back, but I think the primary exception is indeed where if you look at the contract, it says that delivery will be made in Benicia and that at that time title will transfer. Well, again, I've already quoted the 6040 is the civil code. section that addresses scenarios where you have a contract provision, and because of fraud, mistake, waiver, or some other reason, it's not fulfilled, you set it aside. And here's the reality, guys, is we've got contracts that call for somewhere between 14 and 16,000 MSGs. We know that more than half of those never existed. So there can't be a reasonable question that suggests that the delivery term of that contract was capable of being fulfilled. It couldn't be, because those units didn't exist. And as to the evidence as of the number, we painstakingly went through that with the department. I understand that we have different representatives now than we worked with, but we established the number. And then as far as the evidence, what we need to show is that it's more likely than not that those units didn't come into California. We've made the presentation. I can answer questions if you like me to, but to respect the time, I won't repeat it all. But we think that the evidence that conclusively demonstrates it was built by Extreme in Nevada, and that there's no evidence to support it ever came to California, and then we have, we think, sound evidence, objective evidence, that it was located in the same vicinity of where it was built, is evidence that it never came to California. We think that that is further supported by the fact that Benicia had, I want to say, 600 units. US Tower, I want to say, had 1,600 units. And of course, in total, there was approximately 3,000 units in California. So logically speaking and logistically speaking, and from an economic standpoint, it simply wouldn't make sense for, I guess, distribution, in this case, who was responsible for leasing these units, if they needed 100 units to send out to a raceway in California, they would just use the excess surplus that they have on hand. And I think that's frankly why we ended up with so many units in Nevada. They just weren't needed. And we think it's much more likely than not, because they were in an unused condition when they were found, as testified by Ms. Lovato. They just never left. And then, you take that a step further, and we think the law is pretty clear that if it never comes to California, it's just not a scenario where there's a taxable incident.
Thank you.
If I could speak to that,
Yeah.
in particular, California retailer making sales to a California purchaser has a use tax collection obligation, even if they're delivered out of state. Or so again, we just have an issue with the evidence of whether these came here and whether tax was due on them. And the conversation about the audit verification comments and things like that, I want to note that the audit was much higher back then, and we have reduced it substantially after that.
Mr. Turner, I'd also like to just add one thing. We agree with the number of units. His exhibit, the appellant's exhibit 5, it's bait stamp page 80, shows the total number of units. The disagreed units are the 1,051 Extreme units, and those are the ones that we said showed a delivery in the contract to either Concord or Benicia. So that's the dispute, but we agree with the total number of units.
Thanks for the clarification.
And if I just may respond to that briefly, we understand that if products are sold from California and shipped out of state to a California resident, the code section 6247 establishes a rebuttable presumption that they are brought back into the state for use, right? The thing is that Montgomery Ward, the case that we cite, and you have it in the list of authorities, already addressed this scenario as it pertains to property that never comes into the state. 6247, by its own language, specifically references property delivered outside the state. So it's not implicated in this case. So we think the law is pretty clear. To say that there's a factual dispute, I guess, on that front is a fair one, to the extent that the contract says that it's to be delivered to Benicia. But again, and I won't repeat what I just said entirely, but we have to recognize that it's undisputed, and in fact, he just stipulated to the number of units, for example. Well, that's an acknowledgement, and in an appropriate and fair one, that the contracts weren't adhered to strictly. And if they were, then these folks probably wouldn't be sitting in jail, and I wouldn't be sitting here. They didn't. You know, they didn't adhere to the contracts. They didn't produce the units they said they would. They didn't lease it at the level they said that they did. That's, you know, it's a big part of the reason why we're here. And we think it's abundantly clear with the evidence that we've presented as far as where it was manufactured, which has not been disputed, and where it was found, which has not been disputed. That proves by a preponderance of the evidence that it's much more likely than not. We don't have to show much more likely. We just have to show that it's more likely than not that those units never came to California and then were just returned. And the fact that they were in an unused condition, coupled with the fact that we had a very limited number of leases that actually occurred, and there was a surplus of units. And units in California, a lot of the units in California, am I correct that those also were unused? Yes. Okay, so we've got unused inventory in California. There just wouldn't be a reason to incur the expense to bring them to California. So we feel strongly that at a minimum, that adjustment is warranted and well supported. And by the way, we can supplement the record. This is a related, but a little bit different with the SMS database because it's in an Excel format. I'm sorry, it's in a PDF format. We're happy to provide it in Excel. And that would enable your staff or you to very easily analyze it in terms of the type of unit that was found and the percentage.
We'll let you know if that's necessary or not, but thank you
Sure.
for the offer.
Absolutely.
You've answered my questions. Thank you. I'm good.
Judge Ridenhour?
So circling back to the whole shipped on Exhibit 25 that we spoke about earlier when I asked about the ones that were not made in California. When it says status shipped, where are you saying that this is the list of ones that should be taken into account for a re-audit? Am I understanding that correctly? Or an adjustment?
That goes into it. And I don't have it in front of me, but I know what you're referring to. And I understand the question and why there might be concern, because if it says shipped, well, the implication is that it was shipped. And as we understand it, Extreme wouldn't have been the party that's even privy to these contracts. They don't know what, you know, Section 4 of the purchase agreement says. That term shipped essentially means that their production of that product is complete and that it's been shipped. And ultimately, shortly before this process started, I wish I had the photo, of course I don't, but I'll tell you about it. Their yard was filled. You know, this would have been, I guess, early 2018. I had in the file, somebody had taken or produced some Google Earth photos, things you guys can do, actually, of course, as well, at these facilities. And you'll see a field, you know, filled with these things. And then ultimately, Ms. Lovato has testified. She's, I think, a very credible witness. She had a staff that set out to locate these. At least at that time, there was no reason to think in terms of, wow, the results of this is potentially going to impact, our tax issue that eventually came to be. So, we think that all of the recording in the SMS is very, very accurate. It was done under the guise of the court. It had to be presented to the court and essentially declared as accurate. And then these things had to be sold at auction and accounted for, each and every one of them, as part of the trustee's job to then be able to have a full accounting of the amount that is available in the state, in the estate. So I know that's a long answer to your question, but I think it's important to put it into context. Shipped for purposes of that report, as we understand it, simply means that it's shipped for purposes of extreme, not necessarily that it reflects that, I shouldn't say not necessarily. It does not reflect that the units were shipped to California, because they were not, and we have no evidence to support they were.
And it's my understanding there's references of contracts regarding these. However, if I'm understanding it correctly, your position is because of all this fraud, et cetera, these contracts don't have any weight as to whether or not they said they were shipped to I'm understanding?
In part, that's correct. And I would just say that, yes, the fact that there is very well-established fraud is a factor to consider under the law as to what degree certain provisions should reflect the intent of the parties, okay? My point in the earlier discussion is that we know that for certain there wasn't, at some point, an intent to actually deliver all of the units that were purportedly produced under the contract, because Mr. Karpoff knew for a fact they didn't exist. So he couldn't intend to deliver those. Now, here's the thing, Judge, is that there doesn't necessarily have to be fraud in order for that, for a contractual term to be waived or to be breached. And while I acknowledge that contract terms are important, and the California Supreme Court has said the same when it comes to tax matters, if you have a term that says, as it does here, that the product is supposed to be delivered to California, but you have evidence that we have here that we know all the provisions under the contract weren't fulfilled, and we have evidence of where it was manufactured, that's not subject to dispute. Again, we have evidence of where it was found, and we have evidence that there weren't a need for all of the units that existed because they weren't leasing these to anybody. And then we have evidence that there was a surplus of units in California. I don't think any of that is subject to dispute. Like everybody agrees, okay, that's fine. When you weigh that against this provision, understanding the context of this case, including, some serious fraud. This got pretty bad. I think the weight of the evidence certainly supports that these units that have been identified are accurately identified, and that it's more likely than not that they never came to California and then for some reason were shipped back. There's no evidence to support that, and there's just no logic to support it.
Okay, so going back to this is like an issue of fact, right? And so it needs to be decided by the panel. So do you have these contracts and then would be able to say this particular one was said to be going to Benicia, but this is where we found it? I'm kind of wondering, for me, because I'm very visual and I'm very it's the science brain in me, would like to see that. And I would like to see, of these that you claim should be adjusted, should everything else go the way it is, that an adjustment is warranted, have the contract, and then say, of this one, it went here, it stayed here, to itemize each one and provide the contract. I would like to go through all that if you,
100%. And we've provided an exemplar contract, for purposes of efficiency. And I think there's two ways that this can be approached. One, we can leave the record open and supplement the record also with the SMS database in an Excel format that's usable with the associated contracts. I don't know that's necessary. We're certainly open to doing that or any other thing. Here's the reason why it's not necessary is because the department already has done that. So they've done that in the audit working papers, right? So they've gone through and they have identified within the audit working papers what the particular contract says, and that is...
can you point me to the,
I can.
please? Thank you.
I want to say R3 12A3 is one schedule, but I will get there. Let me just... And Judge, that's the basis for how they determined whether or not these should be included or excluded from the liability is based on the contract term. So they've identified, okay, this one had a specified delivery location. We're good with it. We're not going to mess with it. This one specified Benicia. And then to the extent that occurred, those units were all treated as taxable. As I'm saying this, I'm trying to make sure that I'm not getting this wrong, but I'm fairly certain I have it right, and we can get to this schedule. But the operative schedules that we've identified, and before I say this, again, in Exhibit 5, where you get into the individual transactions, what we do is we reference the specific audit schedule in which that ties to. So you could spend the time going back and forth to reconcile these transactions out. And then also look on, let me just open it up. I've got it here. Bear with me. Okay, so I'm looking at what would be, I think, the department's most recent exhibit. It's Re-Audit 4. And the good thing about Re-Audit 4 is it has the various versions of the earlier re-audits. And so, for example, if we get to R3, which is designating Re-Audit 3, right? So
Judge Ridenour, I could give you a bait stamp page if you would like.
That I was just about to ask for.
So the R312A3 is on bait stamp, our exhibits bait stamp page 4188. And it has all of the contracts that we looked at for both audit periods on this schedule.
Thank you.
Thank you, Mr. Parker. That's exactly where I was taking you. So, again, this could be used as a control in conjunction with the notes that are made. So, where it says on column H, let's just take a look at this. So, line reference 13, column H, it says note 1. It looks like that's for Fund 4. So we go down to note 1, and it says, I did not see these contracts. Sherwin-Williams was investor for 3, 4, 5, 11, and it lists all these different ones. The title pass at destination specified by buyer for the SW contracts I've seen, I will treat the rest as the same. So at least for these wouldn't be included in those. Let's just find one that says title pass and capital contracts. So those that apply for number 2, let's just go to note 2, which is line 21, that looks like Fund 12, column H, note 2. Okay, I did not see these contracts. DVVNB Community Renewables was investor for 6/12/19. The title passed in Concord for the contract I've seen. I will treat the others as the same. So in that case, she is essentially potentially correctly concluding that if one contract says one thing, the others with the same investor says the others. I think I've seen at least some of these, and I was able to confirm that. We don't have a dispute in that approach. But the point being is that this document or this schedule here, I think, does what you're after, right? And then from there, the combination of the SMS database, which is Exhibit 9. Now, it's in a PDF form. We're happy to submit that in an Excel form to make it more user-friendly. Coupled with the extreme build report, which we call Exhibit 25, Extreme Manufacturing Production Reports. And then you look at Exhibit 5, which takes all three of these sources. So it takes the extreme build report, it takes the SMS report, and it takes the audit, and compiles all of that to identify the units that remain in the audit that were located outside of the state. And I don't want to put words in the department's mouth, but I'm not even certain that the department disputes or at least asserts based on some specific evidence that these units ever came to California other than the contract term. And I believe that it is that contract term that they are saying this is dispositive, and I just respectfully disagree in that, you know, for one, the law recognizes that a contract term may not be performed. And everybody kind of recognizes that inherently, right? Practically speaking, it just doesn't always happen the way it was planned in all walks of life. So in those cases, you know, you don't have to, I guess, pretend like it did for purposes of how the law applies. You figure out what actually occurred based on the evidence and the facts. And if you can establish, as we have here, that the units just never left Nevada, then you say, okay, well, these are the facts. What does the law say? And we've already discussed the law. We think the law supports that the tax doesn't apply in those cases.
Okay, thank you.
Yep.
One question to both parties, and while I'm speaking to appellant, I'll ask you first. So if, as to the lease of an electric generator, let's say it's not affixed this time, and the generator and the trailer are leased in a single transaction, but again, they're not affixed, okay? How would that be taxed compared to when the generator is affixed to the trailer?
Fair question, and I think that the question is answered effectively in 1593 and 1594, where it parses out items that are and are not MTE and items that are and are not component parts, and the related annotations speak to that. But ultimately, to take your question a step further, because I don't know if you specified it, you referenced trailer, but let's just assume that the trailer is MTE, okay? I don't think all trailers are MTE, based on the language of what the law says, and our position was expressed in the response to the pre-hearing conference Q&A. But let's just, in your hypothetical, take the trailer as one that qualifies as MTE. And then, the question becomes, okay, well, what if that was leased with what amounts to be, the same MSG parts that could be easily removed and then, set up and use at a camping site or something, right? And that it wasn't integrated in the trailer. To me, the tax would apply, as per 1661 and a combination of 1660. Now, interestingly enough, there's effectively still elections, right? Even if it's MTE and it's going to be placed into use for leasing, you still have the right to elect to report tax on fair rental value, which is generally considered to be measured by the lease receipts. So one way is, you know, and probably the way I would recommend it is, well, just collect tax on the lease receipts. Keep it simple. I guess the other option also exists. You know, you could pay tax on the cost. And to the extent you've done that with MTE, you satisfied the obligation. And to the extent you've done that with the TPP, you've satisfied the obligation, no tax due on rental receipts. And truthfully, if it's going to be two separate units, you could have a combination, right? You could have a combination of the two. I mean, again, you know, I understand the question and perhaps can guess where you're going with that, but I mean, here's the thing is these, the construction of these particular units as the build report, you know, the list of the parts helps to demonstrate, and then the photos of kind of the before and after, you know, taking a flatbed and what you end up with, they're significantly different. And at the end of the day, putting steel railing around the frame is, you know, and then the fact that the, you know, the whole body is taken up by the solar panels, absolutely, you know, when they're deployed, and just the size of them. And then you've got the center section that's occupied by equipment as well. I mean, the one thing that the department has said is that there's a job box. But if you, I don't know why they keep saying that, because if you look at the photo, there's photos of the job box open and it's filled with equipment. Like it's, I mean, if you wanted to get creative about how potentially property incidentally could be transported by an MSG, I don't know that you'd even look there. You know, you could probably come up with something else, but certainly the job box wasn't for use in transporting property. So in any event, we think the proper approach, respectfully, is that you have to look at what was sold, right? And you know, maybe in other areas of law like construction contract, you might look at the method of installation or things of that nature, and it could change the outcome. But for retail sales, which is what we're dealing with here, you look at what was sold, and what was sold was not a trailer. What was sold was an MSG. And I think the analysis has to start and end with that, because otherwise, potentially, you go down this slope where, depending on the way it was manufactured, and it was manufactured in various ways, by the way. U.S. Tower essentially built it from the ground up. Forest River essentially built it from the ground up. You know, Extreme Manufacturing took a little bit different approach. So you potentially end up with, you know, with a different conclusion of whether or not it's MTE, even though the end result is exactly the same. And I'm not sure that in, you know, in this scenario, such an analysis proves out to be the appropriate one, if that's a possibility. And if we have certainty in the threshold, which is ability to transport persons or property, we can always go back to that. And if we know the same exact product can't do that, and under one test, the conclusion is, yeah, it's not MTE. And if you take the exact same product and you put it through another examination, and the outcome is, yeah, it's MTE, it seems like something's not quite right there, especially where both, you know, the same product cannot transport persons or property, which is the threshold element for MTE.
Thank you. I would like CDTFA to also answer the question, please.
If you had a trailer that, let's also say for the sake of argument, qualified as MTE, and you were also selling solar equipment and generators that were not affixed to the trailer like permanently, then we would look at them as like different items. and we'd look at the trailers under 1661, and if they were also leases, we'd look at the other stuff under 1660. The annexations kind of talk about this with, I think it's the water boiler units, where there's trailers, so we know that's MTE, but they found that the water boiler units were not MTE because they were taken off of the trailers when they were used. I mean, same thing with pressure washers, right? Like our annexation says that pressure washers that are permanently affixed are considered component parts. So we'd look at it all as MTE. But there's pressure washers that aren't permanently affixed to a trailer and may be transported. We wouldn't consider those pressure washers to be MTE.
I thank both parties for indulging my question. Thank you. No more questions.
All right, thank you. I did have some questions for CDTFA, but we are up against the 240-minute time we had budgeted for this hearing, so I'm going to keep the record open for those questions. Also, Mr. McClellan, I would also like to have that Excel spreadsheet and possibly a breakdown of the units between the model numbers. I'll also keep the record open so that you could provide a written rebuttal in closing, and then depending on the additional submission, and I'll also gather with the panel and see if they have any additional questions for both parties that we will ask additional briefing on, and then provide the other side with appropriate time for responses.
If I may add, for the contracts and all that, the steps you were recommending I take to look at everything, I'd appreciate it if you did that and gave me a document that's easier for me to understand and not could be a forensic accountant for it.
100%. You know, I've spent a lot of time with this myself, and I had someone else on my staff sort of go through the nuts and bolts and create it. And it always takes me another go to really go through and digest it. Once you do, I'm confident that it will make sense and that you'll see it all, but I respect the question, and I'll make sure that we do our best job to, you know, provide it in a way that you can understand without too much trouble. Yep.
All right, so we will keep the record open. Be on the lookout for the post-hearing order later this week or early next week. Thank both parties for the presentations and the witness for her testimony. So we will be concluding this hearing. The record will be kept open. The next hearing will be starting at 1:30. So thank you, everyone. Let's go off the record.
Thank you, everyone.
Thank you.